Mesdames et messieurs, bon après-midi à ceux qui sont ici et bonne journée, quelle que soit l'heure, à l'endroit auquel sont les personnes qui nous suivent en ligne. Pour ceux qui ne me connaissent pas, je suis Marina Schneider et vous êtes nombreux. Je suis la personne qui, au secrétariat d'Unidroit, suit depuis son élaboration la Convention d'Unidroit. Et j'ai le grand plaisir cet après-midi de modérer la session numéro 2 sur les synergies entre instruments. Alors, je ne vais pas prendre trop de temps aux personnes qui attendent et qui vont faire des présentations, mais permettez-moi de rappeler que c'est l'état de droit qui crée la confiance et qui rend les opérations économiques plus fluides. Et ce principe s'applique aussi à la protection du bien culturel et au marché de l'art. Et pour garantir la protection des biens culturels et la sécurité juridique et financière des opérations et des acteurs, le marché doit être efficacement réglementé par la loi. C'est l'état de droit qui définit et impose les instruments et les mécanismes qui permettent de rassurer les parties contractantes et de faciliter les transactions licites, mais aussi de prévenir les transactions illicites. La Convention d'Unidroit le dit elle-même, ce n'est pas le seul instrument et la solution pour mettre fin au trafic illicite, mais elle amorce un processus de collaboration internationale pour maintenir un rôle approprié également au commerce licite et aux accords. Et dans un monde où les transactions légales et illégales se multiplient, l'efficacité de la protection des biens culturels au niveau national, régional et international dépendra d'une interaction équilibrée et harmonieuse de toutes ces règles. Et de ces règles supportées par des instruments dont nous avons parlé ce matin, la base de données d'Interpol sur les objets volés, les listes rouges de l'ICOM et d'autres. Et l'évolution de ces dernières années montre qu'il existe une interdépendance croissante des différents instruments qui régissent le transfert international de biens culturels. Il est donc nécessaire de renforcer leur synergie et de parler de complémentarité entre instruments, et c'est ce sujet que nous allons aborder cet après-midi. Et nous allons l'aborder d'une façon un peu différente, on va dire. Nous avons la chance d'avoir avec nous cet après-midi des représentants des organisations internationales sous l'égide desquelles les principaux instruments ont été élaborés. Présentations qui seront suivies à chaque fois par un exposé d'un professeur de droit qui mettra l'accent sur les aspects juridiques de ces instruments. Et nous allons commencer tout de suite par l'instrument majeur dont nous avons entendu parler déjà à maintes reprises ce matin, c'est la Convention de l'Unesco de 1970. Et pour cette convention, nous allons avoir Monsieur Lazare Elundu Asomo, qui est directeur de l'entité culture et situation d'urgence à l'Unesco depuis 2018. Lazare est également un homme de terrain puisqu'il a travaillé longtemps, notamment au Mali. Il a donc cette double casquette, si je puis dire, et je m'empresse avec grand plaisir de lui donner la parole. Il est avec nous depuis Paris. C'est à toi, Lazare.
D'abord, bon anniversaire, Unidroit. Je crois que c'est important de le dire avec des mots simples. Et j'en profite pour, encore une fois, vous dire à quel point nous sommes heureux de célébrer ces 25 ans avec vous. J'en profite aussi pour saluer le professeur Folarin Shilon, qui lui est un spécialiste de droit. Moi, je ne le suis pas du tout, donc je n'aurai pas du tout la même réflexion. Mais j'ai envie de vous donner, de partager avec vous, en tant que secrétaire de cette convention, depuis maintenant 2 ans, un ensemble de réflexions ou de voies sur lesquelles je pense et nous pensons ici avec l'équipe du secteur de la culture où c'est important d'aller. Alors, c'est pour ça que la réflexion que je souhaitais partager avec vous s'intitule un peu, c'est un peu une réflexion sur l'avenir de la Convention de 70 et en faisant un petit peu le bilan, parce que 50 ans après son adoption, nous avons commencé à nous poser un peu la question et Et donc, c'est une année marquante, effectivement, comme vous savez, et c'est deux célébrations importantes, celle de la Convention de 70 et celle de la Convention UNIDROIT de 95, qui est importante. Et cela représente en fait une opportunité pour qu'on puisse saisir ensemble et tirer des leçons de nos deux expériences et qu'on envisage des perspectives innovantes pour répondre aux nouveaux défis du trafic illicite aujourd'hui, dont beaucoup en ont parlé ce matin déjà. Alors, donc, je vais essayer un peu de résumer certains de ces succès et très rapidement. Le tout premier, et ensuite, vous verrez un petit peu pourquoi je pense que c'est important de le lier à l'effectivité de la Convention d'UNIDROIT 25 ans après. La Convention de 70, on l'a dit déjà depuis ce matin dans de nombreuses interventions, je ne vais pas revenir là-dessus. Ça a été un instrument international absolument important, mais son rôle, en fait, c'était de protéger le patrimoine déjà en temps de paix, pas forcément quand la question des biens culturels qui sont volés ou spoliés ou déplacés intervenait, mais c'était un peu et donc ça c'était important. Mais ce qu'il faut savoir dans cette histoire, parce qu'elle nous poursuit toujours, même 50 ans après aujourd'hui, c'est qu'une convention, quand elle est adoptée, c'est parce que finalement elle regroupe un compromis entre différentes positions qui pouvaient à cette époque, dans les années 70, sembler radicalement opposées. Et c'est ça qui fait cet instrument de coopération internationale. Et c'est parce qu'il y a eu ce compromis qu'aujourd'hui, la Convention est ratifiée par 140 États parties. Si je peux prendre un premier succès de cette Convention, c'est ce que moi je vois de ce côté, c'est que 50 ans après, le public aujourd'hui est beaucoup plus sensibilisé, peut-être pas encore assez, aux questions du trafic illicite et aussi de toutes les parties prenantes qui s'impliquent. Et c'est pour ça, parce que cette convention, elle a exercé une influence sur l'opinion publique et même sur les institutions comme les musées, les institutions autres qui ont commencé à essayer de voir, par exemple, des choses comme la provenance des objets à partir de la convention, de l'adoption de la convention. Mais il y a aussi toutes les dispositions de la convention qui sont relatives à l'éducation au public qui sont importantes, notamment l'article 10 de cette convention qui fait que on peut organiser de nombreux ateliers, des activités de sensibilisation avec tous les partenaires. Mais ce n'est pas tout. Un autre succès, on va dire, qui est important, c'est que la Convention a fait évoluer ce qu'on appelle un peu les mécanismes qui protègent le patrimoine culturel. Beaucoup de mécanismes au jeu sont pas, il y en a même encore récemment. Et quand on voit tout le soutien que la communauté d'archéologues, d'anthropologues, de juristes, issus quelquefois même de la société civile, apporte à ces dispositions de la Convention, c'est extraordinaire. Et rien que récemment, on peut déjà voir ce qui s'est passé avec tout le travail excellent du projet ATAR et d'autres, donc certainement on va en parler un peu plus tard, et la décision de Facebook, etc. Mais il faut continuer à sensibiliser le public, notamment les populations où ces biens culturels sont en danger du fait qu'on se retrouve avec des négociants, des collectionneurs qui accumulent des grandes quantités de biens culturels importés. Donc, il est primordial que chaque citoyen du monde soit vraiment conscient que nous avons tous la responsabilité collective, pas simplement les gouvernements, mais une responsabilité collective de travailler vraiment ensemble pour protéger ce patrimoine. Et ne l'oublions jamais, on ne le fait pas que pour le protéger, mais aussi pour le transmettre aux générations futures parce que ce sont vraiment les témoins de notre histoire. Et ce travail de sensibilisation est important. Et je crois qu'un des succès aujourd'hui, c'est que, heureusement, 50 ans après, on va célébrer cette année la toute première journée internationale de lutte contre le trafic illicite des biens culturels, le 14 novembre, parce que c'est la date à laquelle la Convention a été adoptée. Et la deuxième chose, justement, en rapport avec la sensibilisation du public, et Ernesto Ottone l'a dit dans son message ce matin, c'est qu'on va lancer une campagne mondiale dans à peu près 10 jours qui va cibler en fait toutes les personnes qui souhaitent acheter des biens culturels avec des messages en fait très, très précis. Comme je veux dire, mais je pourrais en parler un peu plus loin. Un autre aspect qui est important du succès de cette convention, après 50 ans, c'est qu'elle a contribué à améliorer beaucoup de cadres juridiques. Beaucoup de pays ont adapté leur législation nationale pour les mettre en conformité avec la Convention. Et ça, c'est quand même quelque chose d'intéressant. Et c'est pour ça que on voit, par exemple, dans la base de données de l'Unesco qui existe sur les lois et que tout le monde peut visiter ou consulter, il y a aujourd'hui plus de 3000 textes de loi qui sont issus de près de 180 pays qu'on a pu répertorier. Et ça, on continuera de faire ce travail et on le fait grâce au soutien, par exemple, des Pays-Bas et de la Suisse que je tiens à remercier. Mais ce n'est pas tout parce que justement, pour soutenir les États dans le renforcement de leur cadre opérationnel et normatif, rappelons-nous qu'en 2011, l'Unesco et Unidroit avaient beaucoup travaillé ensemble, Marina, sur les dispositions modèles définissant la propriété de l'État et les biens culturels non découverts. Et que cette coopération que l'on a eue est aussi celle qui a permis en 2015 de pouvoir travailler ensemble sur les directives opérationnelles qui visaient à renforcer la Convention et qui avaient été adoptées. Je crois que c'est des moments qui sont très importants, qu'il faut rappeler à ce moment où on célèbre le demi-siècle de la Convention, car on doit se fixer des objectifs pour l'avenir, à travailler ensemble et continuer à aider les États membres, les pays et toutes les institutions, les organes législatifs à continuer de transposer quasiment toutes les dispositions et de la Convention de 70, mais aussi de la Convention du UNIDROIT. Quelque chose, par exemple, qui va être intéressant que l'on va faire dans je vais dire les mois, les semaines à venir, on va travailler, c'est cette question du projet de loi modèle que les États demandent de plus en plus et où ce sera l'occasion éventuellement d'aller un peu plus loin sur la question qui a été déjà discutée ce matin, qui est sur la diligence requise, qui est extrêmement important et qu'il faudra définir clairement, notamment à l'adresse des professionnels du marché de l'art. Donc ça, c'est des questions importantes sur lesquelles on pense qu'on va devoir travailler, mais aussi sur un programme de renforcement des capacités. Je crois qu'il est temps aujourd'hui d'aller un peu plus loin dans le programme de renforcement des capacités et les États membres nous le demandent. Ils nous le demandent notamment pour cibler l'Afrique, qui est une des priorités de l'organisation, pour que il faut soutenir les pays africains dans leurs efforts. Et je pense que ça, c'est extrêmement important. Et Vincent Negri l'a très bien expliqué ce matin dans sa présentation. Je pense que ça ne peut marcher aussi que parce qu'il y aura les derniers 18 pays africains qui doivent ratifier la Convention, mais il y a aussi le fait que ces pays doivent ratifier la Convention du UNIDROIT. Et je pense que l'argumentaire excellent qu'a donné Vincent ce matin, il ne fait pas l'ombre d'un doute. Et je pense qu'on doit passer ce message-là sur l'importance de la ratification de la Convention du UNIDROIT. Mais je peux aussi continuer à citer quelques succès. Par exemple, toute la question sur les codes de déontologie, sur lesquels on a pas mal travaillé aussi, parce que même si ces codes sont appliqués sur la base du volontariat, mais elles ont quand même un rôle d'orientation important quand ils sont largement adoptés. Et là, ils peuvent devenir moralement aussi contraignants qu'une loi, même si ça ne l'est pas. Et l'un des codes sur lequel je veux insister, c'est celui sur lequel, ensemble, on a travaillé, qui est le Code international de déontologie de négociants en biens culturels de 1999, qui, lui, comme on le sait, incorpore non seulement la convention, les principes développés dans la Convention de 70, mais également les principes développés dans la Convention d'Unidroit. Donc, c'était essentiel qu'il y ait une cohérence entre les systèmes juridiques dans la lutte contre le trafic illicite, et c'est ce que ce code de déontologie a favorisé. Mais ce n'est pas tout, mais aussi les principes éthiques qui sont extrêmement importants et qui doivent gouverner la profession des négociants en art afin que non seulement ils puissent être compris, internalisés, mais aussi soutenus par le marché de l'art. Maintenant, sur l'avenir, comment est-ce que tout ça devient important? Parce que les questions qui se posent quant à la capacité du code à être efficace, mais aussi la capacité actuelle des directives opérationnelles de 2015 à relever certains des défis qui sont posés depuis leur adoption, ou alors à s'adapter à la pratique que l'on voit changeante actuelle de tous ceux qui sont des négociants d'objets d'art. Toutes ces questions se posent. C'est pour ça qu'il faut revoir ces instruments. Et ce travail a déjà commencé parce qu'il faut les revoir pour refléter les nouvelles tendances du trafic illicite que l'on a pas mal discuté, notamment les questions de vente en ligne qui sont importantes, et intégrer ces principes éthiques dont on a parlé un peu plus stricts. Et ça, cette discussion va commencer dans 15 jours avec la réunion du comité subsidiaire de la Convention de 70 qui va commencer. Et on va continuer ce travail parce que UNIDROIT est un partenaire extrêmement important pour cela. Je voudrais enfin terminer sur la question de la non-rétroactivité de la Convention, parce qu'on en a parlé effectivement beaucoup, elle est souvent soulignée, mais je pense qu'on ne dit pas assez. Et moi, je l'ai découvert depuis que je suis secrétaire de cette convention, que bien qu'on parle de la non-rétroactivité de la convention, mais cela n'empêche pas les gouvernements et les États d'appliquer quand même les dispositions de la convention aux biens qui ont été exportés illégalement avant l'entrée en vigueur de la convention. Ça, c'est, il faut le dire. Il faut le rappeler et ne pas simplement s'arrêter à cela. Bien sûr, c'est une question extrêmement importante et ça va venir peut-être aider le travail qu'essaye de faire depuis 1978 le comité intergouvernemental pour la promotion du retour des biens culturels à leur pays d'origine. Mais je ne veux pas soulever le débat là. Mais comme il m'a été donné de souligner, comme je l'ai fait tout au début de ma présentation, que la célébration de nos 2 anniversaires est extrêmement importante. Il faut qu'on se concentre, à notre avis, sur les mesures de renforcement de nos 2 instruments. C'est pourquoi cet anniversaire, notamment pour la Convention de 70 et qu'on va essayer de faire malgré les contraintes du Covid, ça va être vraiment d'organiser des réunions régionales qui vont permettre de définir un petit peu les priorités de chaque région, comme on l'a fait déjà, on a commencé à faire avec le forum de Cusco, qui d'ailleurs cet après-midi tient sa 2e phase dans quelques heures, et à laquelle des pays vont se réunir pour discuter encore beaucoup plus en profondeur de ça. Donc voilà, grosso modo, quelques réflexions que je voulais passer avec vous sur le côté dynamique et d'actualité de cette convention. Et je pense que Marina, et ça c'est le message effectivement aussi à Madame la Présidente et au Secrétaire Général, que nos 2 organisations sont vraiment partenaires de cette lutte depuis plusieurs années et que nos 2 organisations doivent continuer inlassablement cette lutte et nos 2 organisations doivent appeler à la ratification de la Convention d'Unidroit et nous allons continuer à le faire à toutes les occasions. Merci beaucoup.
Merci beaucoup, Lazare. Merci beaucoup de nous avoir fait ce panorama depuis la genèse de la Convention de 1970 et d'avoir parcouru avec nous les différentes étapes, les succès de cette Convention qu'il convient de rappeler, évidemment, toujours et encore, de la coopération entre nos deux organisations qui ont abouti à d'autres instruments qui ont aussi pour but de renforcer la mise en œuvre de nos conventions et des étapes futures, des travaux que l'UNESCO envisage avec la collaboration d'autres organisations, dont la nôtre. Et évidemment, l'UNESCO le sait bien, le soutien d'Unidroit est évidemment là. Alors, merci beaucoup. Et now we will listen to Professor Shilon. Professor Shilon is a law professor at the University of Ibadan in Nigeria. Professor Shilon is very well known. He's a person who helped many states in Africa to draft their national legislation. You remember you helped UNESCO and UNIDROIT to draft the model provision on state ownership. And you are now going to speak about the complementarity between the two conventions. The floor is yours, Professor.
Thank you very much, Madam Marina Schneider. I'm quite pleased to take part in this anniversary celebration. I'll be talking briefly on the interface and interdependence between the two conventions. The 1970 UNESCO Convention in Articles 3 and 11 define illicit practices. Article 11 is a special provision concerning occupation in time of war, stating that the export and transfer of ownership of cultural property under compulsion will be regarded as illicit. That's an important provision of the convention. Article 10 of the convention attempts to deal with unscrupulous dealers in the art market and obliges states parties to have a dealer's register. Unfortunately, from little inquiries I've made, many countries have not done much to implement this particular provision. The UNIDROIT Convention attempts to deal with the weaknesses the operation of the 1970 Convention exposed. The 1970 Convention was not a particularly satisfactory compromise between market countries and source countries. The weaknesses led to further cultural losses of art objects. While the UNESCO Convention permits state parties to make reservations, the UNIDROIT Convention does not. This is an important point to note between the two conventions, because as we all know, reservations tend to weaken the effectiveness of treaties, because it enables state parties to accept those provisions that they like and reject those provisions that they don't like. And because the UNIDROIT Convention is a scheme under public law, unlike UNIDROIT Convention, which is a scheme under private international law. This has been of great importance, and that is why, with the assistance and help of Madam Schneider, we've tried to urge African countries to join the UNIDROIT Convention because it provides a greater opportunity for African countries to challenge illicit trafficking. The UNIDROIT Convention enables private individuals to litigate in the countries of member states, where UNESCO Convention, it is an arrangement between two governments, and accordingly, private individuals cannot pursue their objectives in the countries where their objects have been illicitly exported, even though that country is a member of the UNESCO Convention. On the other hand, the UNIDROIT Convention permits private citizens to take part in litigation in outside countries. The UNIDROIT Convention therefore confronts the legal constraints that impede identification or current location and possessor of stolen cultural property. I want to highlight Article 8.1 that provides that a claimant to a cultural object may choose a court either in the possessor's country or in the country where the object is currently located. This is an important provision because sometimes you know the location of an object, but you don't know the possessor. So this duality of forums is an important one in the pursuit of fighting illicit trafficking in cultural property. I will mention one recent development. That is, courts in the various countries, particularly market countries, have started to appreciate the importance of not strictly adhering to the principle that the courts of a sovereign country will not implement the public law of another country. The trend started with the case of United States and McLean, and I think it reached its peak in the case involving Judge Schultz and Tockley-Parry. Those two decisions in particular have been quite helpful, and they are very germane in the fight against illicit trafficking in cultural property. I will try to start concluding. The two conventions complement each other and constitute almost a single regime addressing illicit cultural property trade at the international level, though they adopt different methods for doing so. The chief objective of the UNESCO Convention is to ensure compliance with national protective regimes for cultural property between nation states in their bilateral relationships. The key objectives of the UNIDROIT Convention is to restrict the applicability of private law rule, aiding and abetting unscrupulous art trade practitioners. And that is why both UNESCO and UNIDROIT came together and produced the UNESCO UNIDROIT model provisions on state ownership of undiscovered cultural objects. Indeed, as Linda Prott and Florentini have concluded, despite all the obstacles UNESCO and UNIDROIT conventions have had remarkable achievements in their effect on the art industry. At the level of art law, developments that have contributed to the increasing tendency to classify cultural property as human rights has led to a growing interdependence between public and private international law. Second, both conventions have promoted a moralization of the art industry. And here one should mention the due diligence concept introduced by the UNIDROIT Convention. It adds to the moralization of the art market. And dealers and purchasers are put on notice through that provision that you may not easily get away with knowingly purchasing looted cultural property. The interface and interdependence between the UNESCO and UNIDROIT conventions is inevitable. One led to the other, and the one strengthens the other. In fact, there is symmetry in the bad days of the two conventions. UNESCO is now half a century old, and UNIDROIT a quarter of a century old. Without the effective coalition of both, without the effective coalition of both, the fight against illicit trafficking in cultural property and clandestine excavation of cultural objects will be weak and ineffective. Therefore, I will end on my usual note in this discussion by urging that becoming a party of both conventions is an important step towards inclusion in the Committee of Nations, combating the rising tide of theft and pillage of cultural objects all over the world. Membership of both conventions is a mark of the determination of member states of United Nations to fight the scourge of our time, that is illicit traffic in cultural property. The two conventions, as Linda Prott observed, close many of the loopholes that had prevented courts from combating more forcefully the illegal trafficking of cultural objects. And that, in my submission, is the interface and interdependence between the two conventions. I thank you.
Thank you very much, Professor. Thank you very much for your presentation and for showing us and those countries who are constantly asking why should we ratify both conventions. You very clearly explained the similarities and difference between those two instruments. And one point which I would like just to stress for a minute is, because I find it very interesting, we all spoke about compromise to reach such text. And as you said, the 1970 convention, the UNESCO convention, permits reservations, and we hardly speak about reservations. Many states have done reservations, and it's quite interesting because it means that the implementation of the convention differs from one country to another, which is the difficulty. The UNIDROIT Convention has no, as you said, reservation possible, and it reminds me very difficult discussions during the elaboration of the convention. It was a choice for both theft and illegal export. Either a state decides to fight against illicit traffic and takes it as a whole, because it is a compromise, or it doesn't. So thank you so much for this. And now we will turn to another organization who has, in the recent year, elaborated many instruments to fight against illicit traffic in cultural property at the regional level. I, of course, talk about the European Union. And we will now have two exposés on these instruments. We will start with a presentation. We are very grateful to have with us Mr. Hans Ingels, who is the head of the Free Movement of Goods unit at the European Commission's DG for Internal Market, Industry, Entrepreneurships and Small and Medium Enterprises, which is responsible for free movement of goods. And Mr. Ingels, you are with us and you have the floor.
Thank you very much, ladies and gentlemen, dear President, dear Secretary General, distinguished guests, esteemed representatives of states, ladies and gentlemen. It's a great privilege for me to celebrate with you the 25th anniversary of the UNIDROIT Convention on Stolen, illegally exported cultural objects, and to address an audience that represents the diversity of world regions, but also that shares a common vision. The issue of illicit trafficking of cultural property is not only of particular interest to the European Union, but it's also an issue of global significance. Regrettably, we have all witnessed over the past few years a surge on attacks against great monuments of universal historical and cultural significance. It proves that we must never take for granted the protection of world's cultural heritage. Furthermore, although the protection of our cultural heritage evolved very positively across the world, cultural goods are still being misused for many illicit purposes, like the financing of terrorism and money laundering. Therefore, a strong legal framework to protect our cultural heritage at the international level is still very necessary and relevant. Indeed, the illicit trafficking of cultural property poses a serious risk, not only to cultural objects, but also to the collective memory of future generations. And it hinders the potential of culture as a primary factor for economic development. The recovery and return of stolen assets and the combat against organized crime are a major issue, and much still needs to be done for the prevention of the illicit trade of cultural property and for raising awareness among public decision makers, law enforcement agents, and the art market, and the general public on the existence of the phenomenon and its consequences. The European Union, fully shares this common objective to protect the world's cultural heritage. It's not a secret to anybody that the two most preeminent international legal instruments in the field of cultural heritage protection are the 1997 UNESCO Convention on the means of prohibiting and preventing the illicit import, export, and transfer of ownership of cultural property. And of course, the 1995 UNIDROIT Convention, which were very inspiring for the EU's policy making in this specific area. The EU has adopted a comprehensive series of measures in line with these two conventions provisions since the creation of the single market in 1992. The Union protects European cultural treasures from illegal export to third countries via a specific system of export licenses through regulation of 2009. But it also prohibits the trade in illegally removed cultural goods from embattled areas like Iraq and Syria to recent instruments. And furthermore, also the EU has recently adopted another regulation that prohibits the introduction into the Union of cultural goods that were illegally exported from third countries. And finally, there's also a directive that applies within the EU, and that organizes the return of cultural goods that were illegally removed from the territory from one member state to another. That's the Directive 2014/60, which is managed by my service. So there is this comprehensive series of measures, and today the EU, the European Union, is a global leader for the promotion and protection of cultural heritage. Its ambition is to set the highest global standards and to protect cultural heritage by law. This also helps shaping and supporting the economic progress of all the societies in the world. It's true that our legislation, our directive on the return of cultural goods that were illegally removed from territory from one member state to another, is not as strong as the UNIDROIT Convention. The directive, our legislation, provides rather for strong administrative cooperation, enabling member states to secure the return of cultural objects unlawfully removed. The directive, the EU legislation, allows a member state where a cultural object was found to notify the finding in case there are reasonable grounds for believing that it was unlawfully removed from the territory of one member state. The directive, the EU law, does not deal with ownership. This is an area that falls outside the remit of the European Union, according to specific provision in the treaty establishing and organizing the functioning of the European Union. So that's something that the European Union cannot do. And this is a major difference with the UNIDROIT Convention that establishes an effective framework for returning cultural property to its rightful owners, namely in case of theft. Within the EU, the administrative cooperation between national authorities happens mainly through a software system. It's called the Internal Market Information System. This is a software application that enables multilingual and fast exchange of information amongst national authorities. So in case that cultural object is being researched or found, in that case, it all goes to this multilingual platform for the exchange of information on illegally exported cultural goods. And this fosters the communication between national authorities, the physical preservation of the cultural objects, and measures to prevent any action to evade return procedures. If, however, the administrative cooperation between the different member states in the EU is not successful, then the directive, the EU law, provides for proceedings before a national court within time limits set by the directive. And it's true that judicial cooperation is key with this regard, and mutual assistance between the requesting authority and the requested member state is necessary to reduce the costs of court litigation and to guarantee the successful solving of all cases. However, the feedback that we got as a European Commission from the different member states is that judicial cooperation within the EU is often not very efficient, because if you have to go to litigation, this is very often quite expensive. You have to pay a lawyer, you have to pay litigation costs, and sometimes these litigation costs exceed the value of the requested object. The UNIDROIT Convention, on the other hand, on the restitution and return of cultural objects between contracting states, is therefore much more ambitious than the legislation that we have at European level for the return of cultural goods within the EU. So ratification by more countries would certainly constitute a major step forward for the protection of our cultural heritage. It's clear that the directive, the EU law on the return of cultural goods within the EU, only tackles a few problems raised by illicit trade. So the Commission is now preparing a report on the application and effectiveness of this directive, of this EU law, and this report will be published next year. And this report will also indicate avenues for further steps to protect cultural goods in the EU. I must also inform you that the Commission, European Commission published a very interesting study on the dimensions of illicit trade of cultural goods in the EU. The study examines various aspects of illicit trade in cultural goods in Europe. It also discusses approaches to measuring the volume of the illicit trade and explores national and international criminal justice responses to trafficking in cultural goods to identify challenges faced by the relevant law enforcement authorities in implementing effective responses. Furthermore, the Commission also indicated in its Security Union strategy that was published this summer that it will explore how to improve the online and offline traceability of cultural goods. European Union also invested in an Icprcp project. This is the name. It's a network and a digital platform for cultural heritage. And this project has a specific objective, the setting up of an information network and a chart of good practices at European scale. So it tries to gather a maximum numbers of actors engaged in the preservation of cultural heritage. Trafficking in cultural property has also drawn the attention of the Financial Action Task Force within the European Commission as one of the areas for anti-money laundering and counter-financing of terrorism at international level. So you see the spectrum of actions from the EU on cultural goods and cultural property is very broad. It's not as ambitious as the convention, but nonetheless, the EU is very active in the protection of cultural heritage, not only within the EU, but also at the international level. So therefore, ladies and gentlemen, we are all facing major global challenges to implement the existing frameworks for the protection of cultural heritage, but also to keep pace with the global developments in the trade of cultural goods. A strong legal framework like the Convention and its correct enforcement constitute the basic elements. Yet, closer cooperation among authorities around the globe could be much better than what it is now. We all have a common responsibility to do more and to tell our fellow citizens, and especially the youth of today, our children, who will be the leaders of tomorrow, about the importance of protecting cultural heritage. This highlights the importance of the academic project on the 95 Convention as well. We need to pass a message about the value of cultural heritage and to encourage our youngsters to become the new guardians of our common cultural heritage. History shows us that our cultural heritage is very fragile and that its protection, expansion, and integration into policy development should be one of our finest goals and the legacy that we should all be truly proud of. Ladies and gentlemen, I'm sure that today's conference will prove a unique opportunity not only to commemorate the very ambitious 95 Convention and to promote its ratification among all the countries that haven't done so, but especially to take stock and gather momentum for the next quarter of the century. I wish you a very fruitful discussion and thank you for your attention.
Thank you very much, Mr. Ingalls, for your speech and for explaining to us the very ambitious program the EU is still to do and has done in the recent years. We will see also with Sophie Vigneron how the European instruments were inspired, if I may say so, influenced by the UNIDROIT Convention. You mentioned also the Nature project, which is a very important one to which UNIDROIT is proud to be part of. And thank you for mentioning also the UCAP, the UNIDROIT Convention Academic Project, of which we will talk a little more tomorrow. So thank you so much, and we look forward to continuing our collaboration. Maintenant, je vais vous présenter le professeur Sophie Vigneron. Je vais le dire en français, mais je crois qu'elle parlera en anglais. Sophie Vigneron est co-directrice des études supérieures à la faculté de droit de l'université de Kent, en Angleterre. Sophie s'intéresse en particulier à l'intersection entre le droit et les études sur le patrimoine. Et d'ailleurs, je signale que l'université de Kent et Sophie personnellement sont des partenaires de notre projet académique. Je te donne la parole, Sophie.
Participants, colleagues, it is my pleasure to have been invited today, and I would like to thank Marina. I really wish I was in Rome with you and other colleagues. So my co-panelist, Mr. Ingalls, has presented how the EU and UNIDROIT contribute to fighting the trafficking in cultural objects. The importance and impact of this trafficking has also been presented during the opening session. It is a current and acute problem in many countries around the world. So I was given the task by Marina to discuss the relationship between the 1995 UNIDROIT Convention and the EU. This is a complex question that cannot probably be imparted in the time, so I am bound to make general statements, and I'm referring you to my written communication for a more detailed analysis, so I'm asking for your forgiveness. As discussed this morning by Professor Cordero, there is a tension in private international law, and in particular on the issue of enforcement of foreign export license by the law of the forum. This is known as the principle of non-justiciability of foreign export certificates or foreign export licenses, whatever they are called. This was also discussed in the case of Iran and Barakat, which was mentioned this morning. So what the EU instruments, in particular the Directive of 1992 and what the 1995 Convention aimed to do, is to address this shortcoming. Those two texts were groundbreaking at the time of the drafting because they decide and they recognize that a national public law on export restriction can be enforced, or at least that the violation of this restriction can be enforced and will be recognized by the law of the forum. It is therefore, it's a move away from the normal and widely accepted principles of private international law. So I'm going to present briefly the relationship between the UNIDROIT and the EU to start with. And I quite like this picture of Je t'aime, moi non plus. I have to say, this is a song by Serge Gainsbourg. He wrote in 1967 for Brigitte Bardot, but he recorded it again in 1969 with Jane Birkin, and this is how now it's the well-known song. So I suppose Je t'aime moi non plus, because in the drafting of the convention, there have been many back and forth between the two institutions, between UNIDROIT and the EU institutions. Observers were sent in respective drafting committees, and as early as the 1990s, so it started long before 1995 or 1992, distinctions were acknowledged, public statements were made, therefore afterwards to ratify the convention, etc. So there have been many influence, many the UNIDROIT influencing the EU, but also the EU influencing UNIDROIT. These influences are found in different texts. For example, we can see in the definition of ownership. So just a quick word about that. The EU texts do not deal with ownership, contrary to UNIDROIT, because it is not within the remit of the European Union. The treaties, so the treaties shall in no way prejudice the rules in member states governing the system of property ownership, end quote. Therefore, it's very clear that the different instruments can deal with the circulation of cultural objects, the free movement of goods, so circulation of objects, but not property. But the different influence between UNIDROIT and the European Union text instruments can be found in the definition of cultural objects. And for example, it was found in the different travaux préparatoires for the UNIDROIT Convention in particular, direct reference to European community legislations as it was known before 1992. This definition was narrower in European instruments than it was in the UNIDROIT, but since the adoption of the Directive 2014-60 on the return of cultural objects unlawfully removed from the territory of a member state, this 2014 directive that really updated the 1993 directive. The definition of cultural object is now very much similar to the UNIDROIT Convention, and in particular, the value threshold that has been removed, which didn't exist in the UNIDROIT Convention. The concept of due diligence as well was discussed this morning by Professor Renaud, and we can see that there has been an alignment of the concept of due diligence between the EU and UNIDROIT, which also means that due diligence is now part of the different national laws of all member states. And this element could be extended by reasoning by analogy. So by national judge could apply by analogy the appreciation of due diligence to also the appreciation of good faith of stolen artifacts, but that is something that could be done. The time limitation element as well was presented this morning by Professor Jakubowski, and we can see that there has been an alignment between UNIDROIT and the directive. So we can see a convergence since the adoption of the 1960 directive, and this is something to be really pleased about, in my opinion. But what we can see here a difference. If we look at the articulation between the directive or the EU instruments, in particular the directive, and the UNIDROIT Convention, is what is called the deconnection clause. So UNIDROIT is an international convention, and EU law is a sui generis set of rules that are binding member states. Both are binding on state parties who have ratified the UNIDROIT Convention and on member states. So which rule applies to those states? What is the hierarchy? What is the articulation of these different rules? For example, if an object is illegally exported from Greece and is found in Italy, is it the UNIDROIT Convention that applies, or is it the European directive? This is exactly the role of the deconnection, sorry, I put in my slide deconnection, which is a mixture of French and English. It's disconnection. My apologies for that. So the disconnection clause in the convention is a clause that restricts a state party's right to invoke a convention to the benefit of another one. So the UNIDROIT Convention refers to the EU, as we can see in Article 13.3, contracting states which are members of organizations of economic integration or regional bodies. That specifically refers to the EU, if not by name. So we have here three situations. The easiest one, member states are not party to the UNIDROIT Convention, then only the directive applies, for example, France, Luxembourg, Belgium, Germany, etc. If a member state is also a state party to UNIDROIT with a clause of deconnection, then EU law applies. We can see here the red U, so that would be the case Italy, in Spain, Italy, Greece, Finland, and Sweden. And this clause enables member states ratifying the convention to give precedence to the directive in intra-community relations, and were specifically written for the EU, as I'll say. This disconnection clause is not automatic and needs to be confirmed by state at the time of the ratification of the convention. I read that an author mentioned that the European Commission had wished for this to be automatic, and that would have embedded the supremacy of EU law in the convention. But this was not accepted. So this clause was included at the time also when the EU was just beginning to develop a competence and its text for the protection of cultural objects in 92 and 93, and at the time as well when EU law was less effective than the convention. So we can see though, that not all states have chosen or have applied for this disconnection clause. Only 10, or rather 10 state parties ratified the convention before they became member state of the EU, which is the case for Croatia, Cyprus, Hungary, Lithuania, Romania, Slovenia, Slovakia. And to 3 state parties that have no disconnection clause, even though they were member state of the EU, Denmark, Latvia, and Portugal. Norway has also applied for this disconnection clause, also as a member of the EEA, not the EU. So we can see that in this case, the EU law will have supremacy or not, depending on the impact of this clause, which is also quite important because we can see that this creates difference between the different member states of the of the EU. We can look at the instruments that are extra-EU, so recognize in particular the export reg of 2009 and the import regulation of 2019. So the export regulation aims to is the last opportunity for the competent authority of a member state to control that a cultural object was lawfully exported from its state of origin. This is a very important case, and I will talk about the case that Professor Kubowski mentioned earlier of the Simonis and Arts Council, how it was applied in the UK. But also what is important is the import regulation. There was no import control at EU borders for cultural objects, which was a stark difference with other goods relating to health or food. The problem was that because there was no import restriction, when one looted artifact entered the EU, there was no more control within the EU because there is no border control, and this encouraged port shopping. It meant it allowed traffickers to choose the best country to import cultural objects. It also facilitated or encouraged competition between the different member states. It also meant that it was difficult for countries to comply with their obligations defined by the 1970 convention. So it's a great progress that the European Union has created those regulations, has adopted those regulations. It should also facilitate the application of UNIDROIT because that is a point of control of the validity of the export certificates by the country of origin. And finally, I was asked to talk about Brexit. What is the impact of Brexit? Well, the implementation, it's a difficult question. It's a very tricky question. The implementation period is finishing on the 31st of December 2020. So the regulation of 2009 and the directive of 2014 have been abolished or will be abolished from the end of the implementation period, meaning 31st of December 2020 this year. Will the UK become a hub for the trafficking of cultural objects? Who knows? The government has mentioned several times that it wanted to open free port, like Singapore and in other countries, that it wanted to become a frictionless place where things will be moved in and out of the country, or not even rest in the country, would not pay tax in the country, etc., etc. They don't really know what they're doing. Is it important? Is it relevant? Very much. For example, the licenses that were granted by the Arts Council England last year, because those licenses that were granted by the UK, because the item was imported in the UK less than 50 years ago, was worth 13 billion in 2017-18. So that could be the case, for example, that some of these objects came from the EU and others didn't come from the EU. It's impossible to know exactly the proportion, but it's an important market and it's important value, 13 billion. And as illustrated in the case of Simonis and the Art Council England of 2020, and we see here the painting, which was a Giotto painting. This was the last opportunity for customs and for the Art Council as well to control that an object lawfully was dispatched lawfully from its country of origin, in this case Italy. And so this last opportunity is going to be lost. But at the same time, it's only that the boundary will be moved. So it should mean really that the objects that are found in the UK or travel to the UK will be controlled. If they come from the European Union, there will be a control before they come to the UK. So hopefully there will still be able to be this control. As for the government's position regarding UNIDROIT, it is very unlikely that the UK government will agree to ratify the UNIDROIT Convention. It was already said in 2000 by the then Cultural Secretary that the UNIDROIT Convention would involve a change that is far too important, and that the modification, in particular in the right of ownership, would not be acceptable to the country. So it is very unlikely that this will be changed.
Thank you, Sophie. May I just, on your last point, remind some that in 2000, when the committee met to decide whether the UK should ratify the 1970 and or the 1995 convention, the first committee's decision was to ratify only the UNIDROIT Convention. And because of reactions, a second committee met, and of course, the result was exactly the contrary. But we need to remind that the first decision was to, which without the 1970 convention, of course, it's only on restitution, but still this, and thank you also for mentioning the question of the deconnection clause, which is also an example of what states can make of an international instrument. It's a kind of marge de manœuvre that a state can, and it's interesting enough to note that not all EU members have done this declaration. And so what would happen in case of an illegal export, because this is the only way, area where the two instruments overlap, if I may say so. And thank you for the challenging issue of Brexit. One more. Thank you so much again, Sophie, and I hope you'll stay with us for the question time as all the previous speakers. Now, after the UNESCO instruments and the EU instruments, we will discuss other instruments and their compatibility or complementarity with the UNIDROIT Convention and those of the Council of Europe. The Council of Europe has very old, if I may say so, convention. UNIDROIT participated in the 1985. I will give the floor to Mr. Gruden immediately. And now the new convention of Nicosia, but Professor Fromageau will say this. So now we have the privilege to have with us Matthias Gruden, who is Director of Democratic Participation at the Council of Europe. Among his activities and program, there is, of course, culture and cultural heritage. So we will listen to Mr. Gruden.
For inviting the Council of Europe to this important conference and the possibility to look at cultural objects at the crossroads of rights and interests in these difficult times, which do not always allow us to meet in person and which bring extra challenges for cultural objects and property. But let me first congratulate UNIDROIT on 25 years of its Convention on Stolen or Illegally Exported Cultural Objects, which is an outstanding international convention offering mechanisms for returning illegally traded cultural objects. The UNIDROIT and the Council of Europe have a long-standing record of cooperating and coordinating our efforts, and we are very pleased to contribute actively to this conference. There is such an impressive number of national, regional, and international instruments and standards on protecting cultural objects and cultural heritage that one should actually think the problem can be solved. But this is not the case. On the contrary, it seems that the struggle against the trafficking of cultural property has significantly changed. The black market is moving away from traditional means of trading such as flea markets to trading antiquities online through social media and the deep web. And COVID-19 impacts negatively on protection mechanisms and resources whilst the trade is blossoming. Hence, the steady update of strategies and tools to fight illicit actions and transactions is a must. And so is the cooperation among relevant international bodies and among law enforcement agencies. But awareness raising is also topical of the challenges, their implications, and latest developments. When the Council of Europe started to prepare the Convention on Offences relating to cultural property, we could rely on an excellent cooperation with UNIDROIT, UNESCO, the EU, and many other bodies. This was very important. The new convention was not meant to compete with the existing international instruments and standards, but to complete and reinforce them by closing an important gap. The added value of the Council of Europe Convention is that it focuses on criminal law. It aims at preventing and fighting the illicit destruction of cultural property, while at the same time criminalizes offences related to the illicit trafficking in cultural property. By doing so, the Convention indeed replies to a number of calls for action contained in several non-legally binding instruments adopted in the past few years, for example, by the UN Security Council, Unesco, and the UNODC. There are different appreciations of the question of whether a criminal law convention will offer a breakthrough on this complex subject, which, for good reasons, occupies an important number of specialists and lawyers, as are gathered at UNIDROIT. Clearly, not all Council of Europe member states and countries in general have the same sensitivity towards the need to protect cultural property, and hence also the cultural identity of others, by adopting a criminal law instrument. The prevalence of the principles of free circulation and free trade against regulation of markets, here the art market, is strong, and such freedom is closely related to our very dear ideas of democracy and freedom that have helped to rebuild and bring together the continent after the dark years of the Second World War and later after the fall of the Berlin Wall. And yet, when the Council of Europe pushed for this new legal instrument to come through, it did so after years of cooperation with other international bodies and the member states on treating offences against cultural property under civil law, with penalties or administrative sanctions. It did so under the impression of events such as in Syria, Iraq, Mali, and it did so as a human rights organization. We clearly believe that, and I quote, access to movable and immovable cultural heritage and its enjoyment is a matter of right for individuals and communities, and hence cultural heritage protection is a human rights requirement and not a neglectable luxury. A recent study revealed how complex the transnational chains and networks of local looters, intermediaries, and eventually buyers are. Trafficking fuels criminal groups' activities and capacity and is closely related to organized crime. A strong response by member states and international bodies assisting them therefore seems adequate and due. In response to these challenges, international organizations and state entities, including police services, customs, and border agencies, must be able to take the necessary actions to prevent and suppress this illicit trade in cultural property. So where are we with the Convention? 12 countries have signed and 2 have ratified. 3 more ratifications are needed for the Convention to enter into force. This will happen soon, we hope, although we know that the ratification of a convention requires, at times, complex parliamentary processes at national level that can be time-consuming. We have seen this also happening with the Council of Europe's Faro Convention, which is an innovative tool that advocates citizen engagement in the democratic governance of cultural heritage. The Faro Convention is a framework convention. It does not give specific instruction, but offers objectives and fields of interventions for member states to work towards an integrated and participation-driven approach in the field of heritage. Other earlier conventions deal with the architectural, Granada, and the archaeological heritage, Valletta, and yet another convention with the landscape, Florence, and its protection. I am mentioning these conventions signed in these beautiful cities to underline that the Nicosia Convention is one element in a larger set of standards on cultural and natural heritage protection, and that the Council of Europe is much involved with integrated approaches. We tend to see different subject areas seen in their interconnectedness, and therefore develop different intervention tools to deal with them, from standard setting to monitoring, cooperation, and capacity building to awareness raising and education. An integrated approach is also required when it comes to promoting the Nicosia Convention. I like the title of this conference session, Interplay and Interdependence of Rules and of Cultural Instruments, and take it as a marching order for our future efforts. Indeed, what is much needed is enduring, strong cooperation between our organization, mutually supporting our relevant instruments. We must raise awareness overall, and we must push for the issue of illegal trade of cultural objects and offences to cultural property to be addressed very largely to avoid further damage to the world's heritage. We must act now, as the 2019 conference on the Nicosia Convention expressed, calling for a kind of coalition of the willing, embracing all key players. While the Nicosia Convention introduces criminal law responses to an old threat, it also features a catalogue of preventive and other administrative measures, including measures at international level. Cooperation naturally plays a central role in this chapter. Thanks to governments, business and civil society, and formal and informal learning settings are also key for incorporating and passing the central message. We're not just protecting cultural property, but also at the same time meanings that are precious to individuals, peoples and nations, meanings which are fundamental components of their identity, and thus the world's cultural heritage and humanity's history. Given the fact that the Council of Europe has 47 member states, including so-called source, market and transit states, and that the Convention is open for signature to any country in the world, the impact of the Nicosia Convention could indeed be immense. Together with the UNIDROIT Convention, the UNESCO 1970 Convention that celebrates its 50th anniversary this year, the EU regulations and numerous other instruments, we should be able to move forward. I'm much looking forward to your ideas and suggestions on further consolidating our cooperation and commit to fully support these efforts. As lawyers, we know that legal instruments are even more useful when applied, and hence our respect and gratitude is with the law enforcement workers. But legal instruments are also in need of close monitoring and development. And that is why we wish to thank the researchers and legal specialists, including from UNIDROIT, for their important work that is highlighted at this conference and this special anniversary event. All together and all well-resourced, we shall progress. I wish you excellent deliberations and conference outcomes, and thank you for your attention.
We're very grateful to Mr. Gruden for this mark of mutual support, and we are very proud of it, and we will of course continue. And an example of what Mr. Gruden said about the criminalization of the offences, of course, the UNIDROIT Convention is based, on theft and illegal export, which are two offences, and it's important that countries do criminalize specifically offences against cultural property. And this is also important for the UNTOC Convention, for example, the UN Convention on Organized Crime. For it to be used in cultural property, it needs to be a severe crime, and if not, if a country has not a sentence of 4 years jail, it cannot use it. Most of the countries do not have such a sanction in the national law. It's also important, the Nicosia Convention, because it's open, although the Council of Europe is a regional organization, it is open to non-member states. And a very good example is that Mexico has ratified already. It's the second state to ratify that convention, so it's important. And now, Professeur Fromageau va nous expliquer plus en détail les aspects juridiques de ces instruments. Le professeur Fromageau est un historien du droit, ancien directeur des études de l'École nationale du patrimoine, doyen honoraire de la faculté de droit, d'économie et de gestion de l'Université de Paris-Sud. Jérôme est également le président de la Société internationale pour la recherche sur le droit du patrimoine culturel et le droit de l'art, ICHAL, et il est également, ainsi que l'ICHAL, partenaire du projet académique d'UNIDROIT. Professeur, vous avez la parole.
Donc, merci Madame la Présidente, merci Monsieur le Secrétaire Général. Et puis je voudrais évidemment dire tout le plaisir et l'honneur que j'ai à me retrouver ici à UNIDROIT pour cet accueil toujours chaleureux dans cette institution tout à fait prestigieuse à laquelle nous sommes très attachés. Vous m'avez donc demandé de parler de la Convention de Nicosie et des autres conventions culturelles et textes d'ailleurs, je vais y revenir, de soft law, qui, disons de près ou de loin, sont une occasion pour nous précisément de montrer que, d'une certaine manière, le Conseil de l'Europe ne s'est pas désintéressé, tant s'en faut, à la question qui nous mobilise aujourd'hui autour de la Convention UNIDROIT. Alors, cette Convention de Nicosie, elle a d'abord quelque chose de très particulier, c'est qu'elle a été adoptée dans un temps très court, en l'espace d'un an, ce qui est tout à fait exceptionnel, parce que, en général, les conventions elles sont adoptées à la suite de longs travaux, ça peut durer 8, 10, 15 ans, voire plus. Là, pas du tout. En un an, les choses ont été menées de maître, et grâce en particulier à deux experts extrêmement dynamiques, qui ont été Maria Famater, avocate, et puis Alexandre Chéchi, que je salue ici, et qui a joué un très grand rôle, je vais y revenir, dans justement, je dirais, l'intégration du volet culturel dans ce qui était à l'origine un projet purement, strictement envisagé par des spécialistes de droit pénal. En tout cas, c'est mon avis, on pourra éventuellement y revenir par la suite. Alors, le Conseil de l'Europe, en fait, depuis 60 ans, ça vient d'être d'ailleurs rappelé à l'instant, est très actif dans le domaine évidemment de la coopération culturelle. C'est un lieu commun de le souligner, comme dans d'autres domaines, dans le domaine de l'environnement, où il a été pionnier d'ailleurs par rapport à l'Union européenne. Et il y a toute une série de textes, évidemment, qui ont été adoptés, en particulier le premier texte qui encadre, d'une certaine manière, les politiques du Conseil de l'Europe dans le domaine culturel. Je pense à la Convention culturelle européenne de Paris, qui a été donc adoptée en 1964. Et puis toute une série de conventions, alors qui pour certaines sont intéressantes et sont tout à fait passionnantes. Je pense à une convention qui me plaît beaucoup, la convention sur le paysage, la convention de Florence, ou encore la convention de Faro dont on vient de parler. Mais c'est vrai que pour chercher un lien entre ces conventions et puis la convention UNIDROIT, c'est quand même un peu limite. Alors, un peu grâce à Marina d'ailleurs, qui s'était inquiétée de la manière dont j'envisageais les choses, je me suis au fond posé la question de savoir mais d'où venaient toutes ces réflexions. Est-ce qu'il était possible d'abord d'envisager ce qui s'est passé avant la Convention UNIDROIT au sein du Conseil de l'Europe par rapport quand même à ces idées qui sont maintenant consacrées par la Convention UNIDROIT. C'est la raison pour laquelle je vous propose donc d'abord de faire un peu de la préhistoire, de l'archéologie, de l'intégration des principes de la Convention UNIDROIT dans les politiques, dans les actes contraignants ou de soft law du Conseil de l'Europe. Et cette démarche m'a finalement amené à découvrir, parce que j'avoue que je ne savais pas que à l'origine, le projet de ce qui deviendra la Convention UNIDROIT a été étroitement lié aux lois uniformes de La Haye de 1964 sur la vente internationale, donc des objets mobiliers corporels, elles-mêmes fondées sur les travaux menés depuis très longtemps par UNIDROIT, bien sûr. Alors, rappelons ici que dès 1974, UNIDROIT envisageait l'élaboration d'une convention portant loi uniforme sur l'acquisition de bonne foi d'objets mobiliers corporels, dont certaines dispositions, alors ça me parut très intéressant, vont être reprises à l'article 12 du projet de loi de la future Convention de Delft sur l'archéologie, sur les infractions visant précisément les biens culturels, convention qui d'ailleurs n'a jamais par ailleurs été adoptée. Mais dans cet article 12, on précise déjà que le fait, je cite, que l'acquéreur soit de bonne foi rend la loi nationale applicable pour déterminer si l'acquéreur peut invoquer sa bonne foi pour combattre la revendication du propriétaire dépossédé de son bien par voie de vol, cela au terme des articles donc 8, paragraphes 2 et 3, bref, peu importe. L'acquéreur d'une chose volée ne peut invoquer, dit-on, sa bonne foi. Alors, l'achèvement des travaux sur le projet de 1974 a été ajourné finalement, mais ça aboutit quand même à l'adoption de la Convention de Delft, qui est un texte donc, finalement d'application très complexe, qui explique pourquoi finalement il y a eu très peu de signatures, aucune ratification. Qu'est-ce qu'on peut relever dans la Convention qui laisserait penser que à partir des travaux d'Unidroit de 1974, on a insufflé dans la Convention quelques petites choses intéressantes. Bon, c'est sûr que cette Convention ne pouvait qu'échouer à l'époque de son élaboration, les États restant très attachés à préserver leurs prérogatives en matière pénale. Ça, c'est une vraie difficulté. Alors, pour combattre le trafic illicite, les parties s'engagent, au sens de la Convention de Delft, à promouvoir dans le public la conscience de la nécessité de protéger les biens culturels, à coopérer à la prévention des infractions correspondant et dans la recherche et la restitution quand même de biens d'origine frauduleuse et appliquer des sanctions, bien sûr, conséquentes en adéquation avec la gravité de ces sanctions. Plus tard, on note une recommandation de 1988, la recommandation 1072 de l'Assemblée parlementaire relative à la protection internationale des biens culturels et à la circulation des œuvres d'art, lorsque l'on croyait encore finalement que la Convention de Delft emporterait l'adhésion de nombreux États membres. Et là, la recommandation insiste pour inviter les gouvernements des États membres à prendre des mesures en vue d'adopter un protocole additionnel à la Convention de Delft qui affirmerait notamment que la bonne foi de l'acquéreur a pour seul effet de lui permettre une indemnité lorsqu'il est obligé de restituer le bien qui a circulé de manière illicite. Donc, quelques prémices, quelques réflexions qui montrent que le Conseil de l'Europe était assez ouvert sur ces discussions. Alors voilà pour la préhistoire, n'insistons pas davantage. Et au-delà de l'adoption de la Convention UNIDROIT précisément, nous avons la recommandation du 26 mai 1998 sur la Convention UNIDROIT, sur les biens culturels volés ou illicitement exportés. Et on nous dit qu'UNIDROIT est une contribution, on est en 1998, une contribution importante à la sauvegarde du patrimoine culturel de l'humanité, et le Conseil de l'Europe appelle ses membres à agir pour la ratification. C'est pas rien, parce qu'il y a quand même 47 membres, donc on peut rêver, qui brutalement, l'ensemble des États du Conseil de l'Europe ratifiaient, je me tourne vers Marina, ratifiaient la Convention UNIDROIT. Alors, par la suite, je me suis évidemment intéressé à la Convention de Londres et de La Valette. La Convention de Londres, qui c'est vrai, est antérieure à l'adoption d'UNIDROIT, mais l'essentiel, c'est surtout le texte sur l'archéologie, donc la Convention de La Valette, l'impact dans la préservation du trafic, la prévention du trafic illicite, l'impact de ces conventions, évidemment, c'est important. Il y a deux branches, une branche de législation nationale et une stratégie de coopération internationale. Les conventions ciblent surtout les musées pour ce qui concerne les thématiques que l'on peut déceler à travers ces conventions en ce qui concerne le regard vers UNIDROIT. Dans des formations proches, chacune de ces conventions prévoit que les musées et les autres institutions similaires, dont la politique d'achat est soumise au contrôle de l'État, ne doivent pas acquérir des éléments du patrimoine archéologique suspectés de provenir de découvertes incontrôlées, de fouilles illicites ou de détournement de fouilles illicites. Et puis, surtout, la Convention de La Valette développe évidemment une stratégie de coopération. Vous me direz que c'est assez classique dans les conventions relatives au patrimoine culturel, mais le fait est que donc, on insiste beaucoup sur l'intérêt de la connaissance des instances compétentes de l'État d'origine, partie contractante de la Convention. Toute offre suspecte de provenance de fouilles donc clandestines ou de détournement de fouilles officielles, et toute précision nécessaire à ce sujet est indispensable. Une autre manière d'envisager les choses, là on est dans le domaine de la soft law, c'est le travail remarquable qui est accompli à mon sens au niveau du Conseil de l'Europe qui concerne donc les réflexions sur l'effectivité des normes, de la transposition des conventions internationales dans l'ordre interne de chacun des États. Et ce travail a été élaboré à la disposition des acteurs, en fait. Je pense à la cellule d'appui législatif qui a été créée en 1997 et qui fournit un travail d'expertise extrêmement intéressant dans lequel, donc, cellule d'expertise pour ce qui concerne le patrimoine culturel, avec évidemment l'idée de proposer éventuellement une loi, je dirais une loi cadre, avec toute une série de réflexions qui sont directement tirées de la Convention UNIDROIT, concernant précisément les obligations des brocanteurs, des antiquaires, des commissaires-priseurs, des vendeurs aux enchères. On y fait référence explicite à la Convention UNIDROIT à propos des intervenants sur le marché de l'art qui ont une obligation générale de prudence et de diligence. On rappelle que le possesseur d'un bien culturel ou objet volé, qui doit le restituer à droit au paiement, etc., etc. Je n'insiste pas davantage pour gagner du temps, mais vous pouvez consulter ces travaux de la cellule d'appui législatif et vous vous rendrez compte à quel point ces documents sont extrêmement intéressants. Et alors, ils le sont d'autant plus que, évidemment, si on est intéressé par la démarche comparative, par le droit comparé, on a là un instrument très, très captif, en fait. Enfin, donc, il est temps, excusez-moi, je bavarde, enfin, la Convention, évidemment, de Nicosie, le champ d'application est strictement limité à la lutte contre les infractions visant les biens culturels. L'objectif fondamental, donc, c'est de protéger les biens culturels. La Convention se concentre, je l'ai dit, uniquement donc, sur les infractions visant les biens culturels. Soyons clairs, je l'ai dit dans ma petite introduction, alors même que rien ne laissait croire en 2016 que la Convention de Nicosie s'alignerait sans ambiguïté sur les principes de la Convention UNIDROIT, il y a vraiment maintenant, je pense, complémentarité. Alors, à plus d'un titre, il y a une valeur ajoutée, c'est sûr, à travers ce texte, comme l'a rappelé M. Machad-Gruden à l'instant. Je me contenterai simplement d'insister sur 4 points très liés à la Convention donc UNIDROIT, bien sûr, puisque c'est un peu l'objectif de cette intervention. D'abord, sur la diligence, la diligence requise, sur l'acquisition de bonne foi, sur la question de l'importation et sur les mesures de prévention. Voilà, disons, ce que l'on pourrait retenir sous une forme de synthèse pour montrer à quel point il y a vraiment là une sorte d'osmose. Mais je ne sais pas s'il me reste un peu de temps ou un petit peu. Oh, c'est gentil, merci. Je suis ravi. Alors, ne perdons pas de temps, justement. Pour la diligence, soulignons d'abord que la rédaction, c'est intéressant de le souligner, du deuxième paragraphe de l'article 8, voyons tout de suite dans les détails, a fait l'objet de modifications au cours de l'élaboration de la Convention. Il s'agit de la question de l'acquisition par négligence caractérisée, formulation qui se retrouve ensuite, après de nombreuses discussions, sous le terme de négligence grave dans la première version du texte, puis dans la deuxième version préliminaire, on parle on ne parle plus de négligence grave, mais on parle, c'est intéressant, de diligence. La version finale, donc, précise que les États parties envisagent de prendre des mesures concernant certaines personnes, en particulier les professionnels, les collectionneurs, qui auraient dû avoir connaissance de la provenance illégale du bien culturel, mais n'ont pas exercé la diligence requise dans la mise sur le marché des biens culturels. Je ralentis un peu parce que j'imagine que les interprètes doivent beaucoup souffrir. Alors,
comme c'est gentil,
oui.
qui pense à nous.
Mais je vous en prie, c'est avec plaisir. On vise directement donc les professionnels du marché. C'est ça aussi, c'est intéressant, c'est-à-dire que on aurait pu se contenter du terme de recel, en fait. Il s'agit de concevoir un éventail plus large que le simple terme de recel, mise sur le marché, hein, selon le rapport explicatif d'ailleurs de la Convention, la fourniture de biens culturels ainsi que le fait d'offrir publiquement de tels biens à la vente. On souhaite accroître en fait la puissance pénale sur le pays destinataire du bien et sur les professionnels du marché. Sur la question, deuxième point, de l'acquisition de bonne foi, en fait, là, il s'agit de la falsification de documents relatifs à l'origine, à l'historique, etc. On a un regret, je pense que Alexandre le partage avec moi, c'est que au niveau du Conseil et au niveau du comité, on a beaucoup discuté sur la question de savoir s'il fallait intégrer les faux. Parce que dans le domaine de l'archéologie en particulier, c'est une calamité, si vous voulez. On n'arrive plus très bien à savoir si c'est du faux ou du vrai. Et donc, ça aurait été intéressant, en tout cas à mon sens, d'intégrer cet aspect-là dans la Convention. Ça n'a pas été finalement retenu. Alors, donc, voilà pour mon second point. Sur la question est très intéressante aussi, c'est la question des contrôles à l'importation, bien sûr, qui sont fondamentaux, puisque si le pays d'origine des biens n'a plus les capacités d'opérer des contrôles à l'export, évidemment, un contrôle, ça a été déjà dit ce matin, l'importation est essentielle. Et c'est dans cette direction que s'est engagée la Convention de Nicosie, hein, le trafic des biens culturels, s'inscrivant d'ailleurs dans une polycriminalité et constitue un moyen d'alimenter d'autres marchés tout à fait illégaux. Quant aux mesures de prévention, alors il y en a toute une série, bien sûr. Il s'agit de créer ou de développer des inventaires, on l'a évoqué ce matin encore une fois, mettre en place des procédures de contrôle des importations et des exportations, introduire des dispositions de diligence requises pour les marchands d'art, permettre le suivi et le signalement des transactions ou des ventes, encourager les musées et les institutions similaires à respecter bien sûr les règles éthiques, encourager les fournisseurs de services Internet, les plateformes, etc. etc. Alors, en guise de propos inclusifs, de remarques, si vous me le permettez encore, je conclus, c'est promis. La Convention de Nicosie, même si elle ne va pas assez loin dans l'harmonisation qu'on pourrait souhaiter, constitue une base solide pour les initiatives à venir. Il faut espérer que ces initiatives seront nombreuses, tant sur le plan européen que mondial, car seule une harmonisation approfondie et étendue du droit pénal pourra assurer une protection efficace contre les atteintes au patrimoine culturel en général et le trafic illicite des biens en particulier. Et la Convention de Nicosie, c'est ce que j'ai essayé de vous montrer très rapidement, intègre sous son volet pénal un certain nombre de principes consacrés par la Convention UNIDROIT, constituant, à n'en pas douter, un progrès vers une meilleure protection des propriétaires victimes de vols et une plus grande sécurité ou, disons, prévisibilité, pour reprendre les termes de Pierre Lalive à propos de la Convention dont nous fêtons aujourd'hui les 25 ans. Bon anniversaire à la Convention. Merci.
Merci beaucoup, professeur Fromageau. Merci d'être parti, de nous avoir partagé le fruit de ces fouilles documentaires. pour arriver à la convention, l'instrument le plus récemment adopté enfin, il y a la directive sur l'importation, mais un des plus récents. Alors, nous allons nous arrêter, nous faire une pause pendant un quart d'heure, et je vous invite à nous retrouver ici, donc à 4h, à 16h30, heure de Rome. Merci beaucoup. Ladies and gentlemen, welcome back to the meeting on the 25th anniversary of the UNIDROIT Convention on stolen or illegally exported cultural objects. We're resuming our work, and we are still in the session number 2 on interaction and interdependence between instruments. After having examined instruments already adopted and implemented for some of them, we will now go to discuss the instrument from elaborated under the aegis of the African Union. And for this, we have the pleasure to welcome here in Rome with us Ms. Angela Martins, who is Head of Culture Division at the Social Affairs Departments of the African Union Commission. Ms. Martin is the overall coordinator of the African Union Pan-African Cultural Congress too, and she will deliver her speech from here. Angela, you have the floor.
Thank you very much, Madam Marina Schneider. Good afternoon, everyone. It's a pleasure to be here. I would like to start by congratulating UNIDRA for the 25th anniversary of the convention, and also for inviting the African Union to be part of this celebration. I express gratitude to Marina and to all the staff of UNIDRA for facilitating my participation in the event. As Marina has said, I would like to present the African Union model law on the protection of cultural property and heritage. The rationale for developing of this model law is related to a recommendation of the study of all cooperation activities between Africa and the European Union with regards to the protection of cultural property and heritage, which was done from 2013 to 2014. We saw Professor Folarin Shilon here. He was the lead consultant of that study, which recommended the establishment of the African Union model law on the protection of cultural property and heritage. The mandate to develop the law was received from the Executive Council of the African Union in 2015. I'll move on to read this recommendation or this decision by the Executive Council of the African Union. So the Executive Council called the African Union, the Pan-African Parliament, and the regional economic communities and other stakeholders to engage in the development and popularization of the African Union model law on the protection of cultural property and heritage. The next slide is related to the rationale on the protection of cultural property and heritage. So at the African Union, we see culture is where Africa has its comparative advantage with our unique and diversified offerings. From pre-colonial period, the cultural industries have continued to shape economic growth and provide sustenance for a large number of people across the various social and economic strata in various African communities. The unity of the continent is predicated largely upon its history and shared and cultural values. Identifying and protecting the common heritage is therefore fundamental to African unity and development. Key enduring evidence that Africa contributed to early human civilization. Continuing on why we should protect our heritage, as stated by the model law, preserved objects validate memories, cultural properties tell our histories, human history provides concrete basis for and validate ideas, promote cultural diversity and human capital development, and protecting heritage is a matter of honor and dignity, which was already and has been, most of these things have been mentioned by speakers today. In the picture there, you have some banned historic manuscripts of Mali. Also, why should we protect our heritage? This is inscribed in the African Union Agenda 2063, which is the 50-year blueprint development document of the African Union. And in its aspiration 5, it states, an Africa with a strong cultural identity, common heritage, values, and ethics. The study that I referred to in the beginning, which recommended the development of the model law, found some gaps in the protection of heritage in AU member states. So there are no robust laws to protect cultural heritage and property in AU member states. Many member states were not adequately resourced to create robust laws. There are weak frameworks identified, particularly the non-ratification and domestication of the various conventions regarding cultural property and heritage, poor communication and awareness activities for the protection of cultural property and heritage, and the lack of cooperation in this regard. The speaker this morning mentioned cooperation as a key element in this exercise. Lack of sustainable structures for the protection of cultural property and heritage in the member state also resulted in uncompleted actions in the sector. Other issues that the research study raised was the lack of ratification of UNESCO 1970 and UNIDROIT 1995 conventions for the protection of cultural goods and illicit trafficking by African Union member states. Also, the issue of legal follow-ups on cases of illicit obtaining of cultural goods, which is the way to go. The 1995 UNIDROIT Convention spells out what can procedurally be done in this regard. On strengthening and upgrading of legislation, model legislation provisions were advised. Attention should also be drawn from UNESCO and UNIDROIT model provisions. On governance and legislation, AU member states should ratify, domesticate, and implement the 1970 Convention on Illicit Trafficking, and also the UNIDROIT Convention, and also other international instruments in this regard. This should be done in conjunction with the establishment of national regional committees for the protection of cultural property and heritage and the fight against illicit trafficking. Now I move on to the process of development of the AU model law on cultural property and heritage. The African Union established a working group to develop this model law, composed of cultural experts, anthropologists, historians, curators, lawmakers, and members of the Pan-African Parliament as well. The drafting process, as I mentioned earlier, started in 2015 and was concluded in 2018. There was a validation workshop in 2018, and the final document was submitted to member states for inputs, and final draft was also submitted to ministers of youth, culture, and sport, which was held in Algeria in October 2018. The composition of members of the working group, as I mentioned, members of parliament, culture and heritage experts, and then we have here the times when the working group was meeting, but most of the time the working group was working remotely because we did not have enough resources to develop the law. UNESCO was also part of this process. As you can see from this slide, in their page on the 9th of September 2017, they mentioned that they are participating in the process of development of the African Union model law on the protection of cultural property and heritage. So what is this law and what is the aim of the law? The law is a continental instrument which is aimed at assisting African Union member states in developing their national legislation or revising and strengthening their current legislation on the protection of cultural property and heritage. The law has 44 provisions. So these are the provisions that the law has. We have issues, for instance, on Article 24 related to education, research, and training. On Article 39, we have war and armed conflict, which, as you are aware, it's destroying a lot of heritage in Africa. We have article related to offenses, intellectual property rights, amongst other. The core strategies of this model law, like I mentioned, prioritizing education, the sharing of knowledge and transmission of our tangible and intangible heritage. Under security, the issue of human tragedy, which is also not also accompanied by an irreplaceable loss for the record of humanity. Ensure regular risk assessments, establish centrally coordinated registration of African antiquities and cultural objects outside Africa to build a robust database. I've mentioned somehow this already. The AU model law used the Agenda 2063 as one of its framework. Also, someone in the morning, a speaker in the morning mentioned the Egyptian law on antiquities 117. So this model law was also had a thorough review of that law, and some of the provisions are based on the Egyptian law 117. The AU model law vests ownership of cultural property in the state or on authorized persons only. It provides for the establishment of competent national authority to protect the cultural property and heritage. It provides for community participation in the preservation of protection of cultural property and heritage. It identifies avenues for funding. Also, licensing to regulate import and export of cultural property and heritage, as was mentioned here today. Guidelines on lending of antiquities for exhibition abroad, impact assessment prior to any excavation, offenses, sanctions and penalties, and regulates trade on cultural property and heritage. So after the finalization of the draft AU model on the protection of cultural property and heritage, as I mentioned, we took it to the Ministers of Culture meeting, which was held in Algeria in 2018. And they adopted the model law and requested that we present the model law to the Ministers of Justice and Legal Affairs and for final adoption by the Assembly of the African Union. The model law was scheduled to be considered by the Ministers of Justice and Legal Affairs in October last year, but it was then shifted to May 2020, but due to COVID, the Ministers of Justice have not met yet, but in their next sitting, they will consider this instrument, which we don't foresee it will have many more revisions or many more things to change because the content of the law was adopted by the ministers. The meeting of ministers also called for the development of the model law implementation guide, as well as the domestication and popularization exercise to start. it was in line with this decision of the ministers that we organized the first popularization workshop for West Africa member states, which was held in Cotonou, in Benin in May last year. So what is the impact of this law thus far? The model law has informed the development of laws, of national laws in some of the member states. I can mention here, for instance, the Republic of Guinea, which finalized their law. I hear Professor Shilon was also one of those instrumental persons that assisted Guinea in developing their law. So Guinea came to the model law popularization exercise in Benin and informed us that they had used the AU model law as a guide to develop their own. The model law has been well received by West Africa countries and also by other member states, and we hope to organize other popularization exercises in the coming months. Experts called for the establishment of synergies between the AU model law and the protection of cultural property and heritage with the ECOWAS heads of state decision on the return of illicit trafficked cultural goods. So this was a call that experts in the popularization workshop for West Africa, they made. Also, they called for the translation of key documents, including the African Union model law, in vehicular cross-border languages. Finally, what are our plans with regards to enriching and popularizing this instrument? The Assembly of the African Union has declared 2021 as the year of arts, culture, and heritage. We are currently in the process of finalizing the concept note for the year of arts, culture, and heritage, and the member states of the African Union have called for a section on restitution of cultural property and heritage to be part of this exercise. So we hope that the model law and all the other instruments related to the protection of cultural property and heritage will be used next year in this restitution process. We hope more member states will be ratifying international conventions through the exercises that we are going to do for the year of arts, culture, and heritage. Finally, I wish to mention the establishment of the Great Museum of Africa, which is a flagship program of the African Union Agenda 2063. It is going to be based in Algeria. We have finalized the concept document of the museum. We are now developing the statute of the museum. And in the meeting of ministers in 2018, they also called for the Great Museum of Africa to be the hub for illicit trafficked cultural goods on the continent, and also to initiate negotiations for the return or restitution of culturally, illegally trafficked cultural goods. The temporary site of the Great Museum of Africa will be launched next year in Algiers, even though we have not yet started building the actual Great Museum of Africa. The government of Algeria has offered the African Union a villa to start operating as the Great Museum of Africa. I thank you very much.
Thank you, Mrs. Martins, very, very much. Your presentation shown not that much the complementarity between conventions, but the interaction between such a model law and national legislations to enhance for a better, as you said, for states to ratify, domesticate, and implement conventions, because our conventions are built on national legislation, and we know that the traffic in cultural object is also based on gaps in national legislations and differences in national legislation. So such model law is very important, and we heard before Lazare Lundu saying how states are requesting in other parts of the world too such instruments. So thank you very much indeed, and be assured of UNIDROIT's support in all the activities that you are planning and wishing to involve UNIDROIT, and we thank you so much. This morning, we spoke several times about the fact that for restitution, you go to court, but it's not the only way, and we heard that it may be costly, that states or private person will prefer not to go to court. So we have now a presentation of other ways to obtain restitution, the out-of-court settlement in cultural property disputes. And for this, we invited Professor Irini Stamatudi, law professor at the University of Nicosia, Cyprus, and visiting professor at the International Hellenic University in Thessaloniki, and lawyer at the Supreme Court of Athens, Greece. Irini is also on the list of the Wipo, Unesco, and Icprcp list of mediators and conciliators. Irini, you have the floor.
Thank you, Marina. Good evening to everyone. I would first of all like to thank you for this very kind invitation. I'm very honored, especially because I know that Maria is both the heart and the face of the UNIDROIT Convention. So I'll try and share my screen now and see if it works. Good, I hope you can all see. So indeed, I will be speaking about the out-of-court settlement of cultural property disputes in the context of the UNIDROIT Convention. But first of all, we need to start with some preliminary issues. Of course, we shall be dealing with cross-border disputes concerning the return and restitution of stolen and illegally exported cultural objects. Yet the question that arises here is how we understand the term culture property. And of course, we do not all understand it in exactly the same manner. Different states understand different things by the term culture property, depending, of course, on their history, mentalities, interests, and of course, their national laws. International instruments, such as the UNIDROIT Convention, offer some common denominators, regional legal instruments too, such as the EU legal instruments. And of course, I don't want to take up too much of your time referring in detail to the 1970 UNESCO Convention, but we have already discussed that the UNESCO Convention and the UNIDROIT Convention are complementary conventions, and more or less they understand in the same manner the definition of cultural objects. And of course, it was also mentioned that EU law has come very close to the UNIDROIT Convention, but that does not necessarily mean that all states have incorporated all instruments in exactly the same manner. On top of that, these common denominators are relevant for interstate disputes only to the extent that the states involved are bound by these legal instruments. There is also a lot of discussion that ADR is suitable for cultural property disputes because cultural property disputes are different compared to other types of disputes. And of course, that question that arises here is, how is that possible? In what respect? Of course, we're talking about interstate disputes, but when we're talking about cultural property legislation, national, EU, and international, we usually mean very specialized legislation and sometimes complex legislation. But it's not everything about law. Apart from the legal issues involved, there are also ethical and moral issues. We may have claims which are not legally actionable because, for example, they're statute barred, but they still remain unjust or unethical, such as the cases of Nazi-looted art, human remains, and so on. Apart from that, cultural property objects present particularities. They have historical aspects, religious connotations, spiritual phases, anthropological aspects, and so on. And of course, this cannot always be taken into account by courts. And of course, cultural objects are usually not always, but are unique objects. They carry special values, and on many occasions, they're not interchangeable. That means they cannot be substituted by another cultural object. There are also other parameters that need to be taken into account when we deal, for example, with reputable collectors, prestigious museums, auction houses, culture property institutions. Most of them do not want any bad publicity. They do not want to have any effect on their reputation. When we're dealing with states, states have the ability to exercise diplomacy. Some see culture property as a chance for a gesture of goodwill or as a means for fruitful cooperation, and so on. On top of everything, there are also issues of jurisdiction and applicable law. Just to put it simply, which court decides what law applies, can a judgment be enforced in another state? Now, let's see how the UNIDROIT Convention deals with those. The UNIDROIT Convention, we said, that has the particularity that it also refers to private parties, so it also allows non-state entity claims, something which is not true, for example, for the 1970 UNESCO Convention. According to Article 8, the parties may agree to submit the dispute to any court or other competent authority or to arbitration. And here we see an express reference to arbitration. So the UNIDROIT Convention is open both to litigation and to ADR. Very interesting is also Article 9, which provides that a contracting state may apply rules more favorable to the restitution or the return of stolen or illegally exported cultural objects compared to what the convention provides, of course, but another state is not under an obligation to recognize or enforce a decision of a court or of another competent authority that departs from the provisions of the UNIDROIT Convention. Now, ADR has a list of different types of out-of-court dispute resolution. One of the most known one is arbitration, but arbitration is that type, the sole type of ADR that comes very close to litigation. And the reason for that is that it is based on strict legal doctrine, usually drawn from the law of a particular national legal system. Of course, it is more flexible. It is not always more cost-effective, though. An arbitral award, which is a decision, is a final and binding decision on the dispute, as would the case be with a court, which can be internationally enforced under the 1958 New York Convention for the recognition and enforcement of foreign arbitral awards. Also, an award is a decision on the request for relief and cannot go outside of this scope. It does not take into account, for example, ethical considerations, moral considerations, and so on. Yet, the remaining types of ADR do take into account non-legal issues and therefore are considered to be less invasive and therefore more flexible. One example is good offices. We find the example of good offices in the 1954 Hague Convention, its second protocol, and in the 1970 UNESCO Convention. Good offices do not have nothing to do with an energetic intervention to the dispute. They aim only to ease relations between the party and try and bring them to the table of negotiations and hope that the parties themselves will resolve the issue. And then we have mediation. Mediation offers a neutral and affordable, usually can be a cheap procedure, and third-party assistance proceedings. So we do have a third party here, or a commission, a group of third parties. It depends on the parties to the dispute what they shall decide. It is a highly flexible, informal, and effective manner through which the parties may resolve the dispute by reaching a mutually satisfactory solution. And it addresses not only legal positions, but also ethical, moral, and cultural issues. And we say that it is highly flexible because the parties may even decide the rules of the procedures themselves before they set off to resolve the dispute. And then we have another type of ADR, inquiry and fact-finding, and it is used in disputes that are factual in order to shed light on the true facts and does not involve the application of legal rules. And then we have conciliation, which is not so widespread, and in fact is a combination of mediation and fact-finding. And it involves usually a commission, a body, which examines the dispute concerning all legal and factual circumstances and suggests a non-binding solution to the parties. Conciliation seems particularly appropriate in sensitive cases where no legal basis exists, for example, where a claim has been statute barred, but it is also used as an instrument to avoid disputes. And then you all know negotiation, which sometimes works as a pre-stage to mediation. This is the case, for example, of the 2001 Convention on the Protection of the Underwater Cultural Heritage. Both parties themselves deal with the issue rather than involving a third party. Of course, we cannot preclude the case where a third party may be involved at a second stage. And then we have not-for-profit dispute resolution services. An example is Art Resolve that was inaugurated in June 2000, which in fact plays the role of a private mediator. And the aim is to achieve a solution that would be acceptable by the parties and which does not rely solely on legal doctrine. And then we have interprofessional agreements. And an example is the Rare Books Group of the Libraries Association and the Antiquarian Book Dealers Association, which was concluded in 1996 in the UK and concerns the resolution of claims relating to antiquarian books stolen from libraries and acquired by book dealers. Of course, interprofessional agreements may be reached when, for example, negotiations have preceded. So you see a long list of different types of ADR. But apart from that, parties may come up with their own types of ADR. We had such examples in the UK. In the case of local or governmental panels set up ad hoc for the resolution of particular disputes. One example of a local panel was the Repatriation Committee that was set up by the Glasgow City Council, and in 1998, it decided on the basis of criteria it set itself to return the Lacoste dance shirt to the Wounded Knee Survivors Association from one of the museums that was under the control of the Glasgow City Council. And we also have an example of a governmental panel with a very similar role that was set up in 2000 by the UK Minister of Arts. This panel did not have a decisive role as the previous one. It had an advisor role and dealt with claims against UK public museums by persons who lost possession of cultural objects during the Nazi period, specifically between 1933 and 1945. And this panel was called Spoliation Advisory Panel and examined the claims submitted to it on legal and on moral grounds. Similar panels have been set up in many other countries. And of course, we also have cases of ad hoc committees, but here we're talking about an open-ended list. So in this respect, we can actually realize how flexible ADR is. And I'll say a few words about the advantages of ADR. First of all, as you may have already realized, there are many forms and types of ADR, which vary from the resolution of the matter to consultation tools. ADR can be less expensive and time-consuming compared to litigation, and that is very important for certain private parties that cannot afford litigation or developing countries. It provides for neutral and international resolution methods. You do not have to opt for one or another jurisdiction, for example. And the reality is that courts are not always well equipped and confident to deal with this type of cases that usually have a cross-border character, and the law can be vague, complex, confusing, and very specialized. Also, State mentalities differ on the matter of protection of cultural property. However, when ADR takes place, can take into account the different mentalities. For example, some countries consider them simple chattels when it comes to cultural property. Some others do not allow for private ownership at all. On top of everything, this type of disputes may involve multiple interests, individuals, states, indigenous populations, ethnic groups, museums, galleries, auction houses, and so on. ADR is flexible enough to take all aspects and interests into account. So, ADR does not take into account only legal, but also ethical, moral, social, scientific, and humanitarian aspects. And what is most important, it may lead to creative solutions. It may lead to win-win situations, whilst when you have recourse to courts, you cannot avoid having a win-lose situation. Apart from strict legal doctrine, ADR can also take into account customary rules, ethics, practice, and the parties, of course, may choose the applicable law, the language and the place, as well as other procedural matters, since ADR, of course, is based on the consent and agreement of the parties. Also, they are confidential unless the parties wish otherwise, and they may apply even when recourse to the courts is not possible. For example, a claim has been statute barred. We all know, especially the ones that are lawyers, that the court judgment can be highly uncertain because of the different legal traditions and attitudes between the states. And a court's outcome, as we already mentioned, may lead to a win-lose situation solely based on legal grounds. Also, an unfavorable outcome, a bad judgment may prove detrimental, not only to the case, but also to future cases, as it sets a precedence for the future. Also, by ADR, you avoid having contradictory judgments if actions are filed for the same dispute in different jurisdictions. A classical example is the clash between the nemo dat quod non habet principle and the bona fide procedure in continental Europe. Also, it's not always easy to enforce court judgments of another state. In any case, of course, you cannot force a party to go to ADR. The outcome is enforceable only as a contract, with the exception of arbitration and the exception of the Singapore Convention on Mediation. You cannot oblige a party to furnish all evidence available. You can do that if you have recourse to courts, and the positive judgment works as a strong precedent for the future. Now, as I'm not left with a lot of time, I just want to mention the fact that international organizations do have a role in ADR if the parties, of course, choose, because everything is up to the parties. We have the example of the UNESCO Icprcp rules of procedure for mediation and conciliation. These came into play in 2010. As far as I know, no use have been made of them. The first time that there was an attempt to make use of them was when Greece asked UNESCO to ask the UK to accept mediation for the resolution of the Parthenon marbles case. Unfortunately, after invitation was sent by Irina Bokova of the time, there was a decline of UK 19 months later. Now, of course, these rules have changed. You need to reply within 6 months. Now, I won't go into detail about the characteristics. It's a very flexible procedure along the terms we discussed. There is also the Wipo Mediation and Arbitration Center, which deals with art and culture heritage disputes within Wipo, of course, the World Intellectual Property Organization. It has various types of resolving the disputes. There is the Wipo arbitration, the expedited arbitration, and the expert determination. And then we have the ICOM Wipo Art and Culture Heritage Mediation, a coalition of two very important organizations, the International Council of Museums and the World Intellectual Property Organization Arbitration and Mediation Center. There, they have developed a special mediation process for art and culture heritage disputes. And I also need to refer to the 2018 Singapore Convention on Mediation, which is also known as the United Nations Convention on International Settlement Agreements resulting from mediation. It entered into force a few days ago on 20th September. 53 signatories, not ratifications. It applies to international settlement agreement resulting from mediation, concluding by parties to resolve a commercial dispute. And what's the innovative issue? Businesses seeking enforcement for a mediating settlement agreement across border can do so by applying directly to the courts of countries that have signed and ratified the treaty instead of having to enforce the settlement agreement as a contract, which is the rule, of course, in accordance with each country's domestic process. I shall conclude here by saying that almost 90%, perhaps even more, of the cases are settled outside courts, and most of them through negotiations. And this is a reality that the 1995 UNIDROIT Convention has taken into account and therefore is flexible enough. There are several examples from all over the world. Some examples where I have been involved personally are the disputes between Greece and the JB Museum. You see on your screen the Macedonian golden funeral wreath that has been returned in Greece in 2007. We have a case of Greece and Leon Levy and Shelby White collections from New York, and the Parthenon marble case, which is still pending, and we just hope that one day will be resolved. For more about these cases, you can find it on the International Journal of Culture Property. Thank you very much.
Thank you very much, Irene, for this presentation on out-of-court settlement. And without, I don't want to, I'm sure there will be questions for you during the session. So in order to have time to take those questions and give time to the next and last speaker of the day, not exactly the last, I will give the floor to Jorge Sanchez Cordero, who is a member of the Governing Council of UNIDROIT. He is a practitioner and notary in Mexico. Mr. Sanchez Cordero was also the vice president at the diplomatic conference which adopted the convention, but he was also instrumental during all the elaboration of this convention. He's also director of the Mexican Center of Uniform Law. And Jorge Sanchez Cordero is going to talk to us about the work that remains to be done. It's on the UNIDROIT work program, the private collections. And of course, we spoke until now of instruments. Collectors have to abide also to many rules. And so I'm very happy to give the floor to Mr. Sanchez Cordero.
Excellences, Mesdames et Messieurs, bonjour. Madame la Présidente, je vous remercie de m'avoir conféré la parole. Les thèmes culturels sont-ils encore actuels dans l'agenda d'UNIDROIT, où la tâche culturelle d'UNIDROIT était terminée dans le cadre de la Convention de 1995, dont nous fêtons aujourd'hui le 25e anniversaire? Voilà la question que j'aimerais aborder aujourd'hui. Il y a, à mon avis, encore des thèmes à développer, et parmi ces thèmes, il y a celui des collections culturelles privées. Les collections culturelles privées représentent sans aucun doute l'un des domaines dans lesquels l'art, la science et les droits interagissent intensément, et cette interaction donne aux biens culturels une spécificité particulière. La collection est une pratique inhérente à la nature humaine. La symbiose de la classification et des collections est devenue incontournable. La taxonomie a transformé les collections en un concept viable. Depuis lors, les collections faisant partie de la nature humaine ont été un catalyseur pour la classification. Les questions concernant les collections culturelles se succèdent. À notre époque, l'interrelation entre collections et collectionneurs introduit de nombreuses questions et des défis juridiques. Il a été dit à juste titre que les collections culturelles privées sont les filles de notre époque. Cela reflète un changement dans les canons culturels quant à la signification des collections culturelles qui se déplacent entre différentes alternatives culturelles. Tous ces éléments obéissent à l'intérêt public. Leur hétérogénéité contrarie souvent tout effort visant à les systématiser dans une perspective d'ensemble. En outre, une étude comparative des différents systèmes juridiques montre qu'il n'existe pas de régime juridique spécifique reconnaissant les collections privées. Cet effort finit par être épuisé par certaines dispositions dispersées et isolées dans différents systèmes juridiques. La scène internationale n'est plus pas prometteuse. Les efforts internationaux maigres sont en cours pour promouvoir et protéger les collections culturelles privées. Le premier effort international sérieux se trouve dans la Convention d'UNIDROIT. Depuis sa conception, beaucoup d'encre a coulé en analyse bien structurée. La preuve en sont les excellents rapports que nous avons reçus jusqu'à maintenant. Le verdict du temps a été favorable à cette convention et l'ordre culturel émergent a été renforcé grâce à cet instrument très utile. La Convention d'UNIDROIT est un élément privilégié qui dynamise les nouvelles ordres culturelles internationales. L'une des ces contributions importantes est la création d'un nouvel espace culturel de liberté dans lequel l'élaboration des dispositions relatives aux collections culturelles privées est toujours en cours. La Convention de l'UNIDROIT est le seul instrument international conférant aux collectionneurs privés le droit d'agir en justice et demander la restitution des biens culturels volés qui faisaient partie de leur collection. L'effet culturel de la Convention de l'UNIDROIT est prévisible. La Convention de l'Unesco donne aux États nationaux le pouvoir de déterminer quels biens culturels doivent être protégés en raison de leur importance culturelle. Cela crée une hégémonie culturelle. La Convention d'UNIDROIT, en donnant aux collectionneurs la possibilité de saisir les tribunaux, provoque une rupture de cette hégémonie culturelle et ouvre ainsi un espace culturel de liberté qui doit être développé. La tentative de délimiter leurs contours s'est révélée être une tâche herculéenne, en raison des multiples limites qui apparaissent entre autres et des points tangents avec d'autres domaines des disciplines sociales, tels que les secteurs des musées, les ventes aux enchères et la législation sur les droits d'auteur, entre autres. Les collections privées sont en constante progression et leur importance culturelle et économique augmente. Cela est particulièrement vrai si on considère que les ressources publiques sont de plus en plus rares et devraient devenir de manière prévisible au cours des prochaines décennies. Les collections privées occupent une place importante sur le marché international de l'art et n'ont dû faire face à aucune bataille sur leur chemin. La principale préoccupation concerne la législation et les obligations incombant aux collectionneurs, telles que celles liées aux soins et à la sauvegarde de la collection, auprès de leurs objets, au taux d'imposition applicable à leur possession ou à la vente des collections, entre autres. Parmi celles-ci, deux semblent fondamentales. Déterminer qui bénéficie du droit d'agir en justice en tant que collectionneur, et la seconde, conséquence de la première, consiste à délimiter les contours de la collection culturelle. Pour élucider qui est un collectionneur dans ce contexte, il est nécessaire de déterminer la différence fondamentale entre les collections publiques et privées. La motivation pour la création des collections privées est très polyvalente. Refuge financier, philanthropie, statut social, lien avec des musées prestigieux ou des legs, entre autres. Certains collectionneurs affirment qu'ils sont même provisoires, les trustees de certains matériaux scientifiques et de certaines œuvres d'art, et qu'ils n'ont pas le droit de priver les autres du même plaisir esthétique dont ils jouissent comme collectionneurs. Ces arguments créent une convergence entre les notions des musées privés et publics. Les collections privées ont généralement un caractère institutionnel comme le secteur des musées et l'accès public à ces collections. Les trustees du musée cherchent à attirer l'attention des collectionneurs en préservant les noms des donateurs ou des testateurs dans les salles d'exposition. Par ces moyens, ils essaient d'enrichir les atouts du musée. Les collections sont devenues des atouts financiers importants, une source de revenus à partir de la science et de l'art et une expression de l'identité. L'accent est mis sur la précision de la notion même de collectionneur. Dans une autre perspective, l'exposition privée des biens culturels ont été et continuent d'être très controversées et aussi entre deux extrêmes. En extrême, se trouvent les arguments des pays où le marché international de l'art est florissant et facilite la constitution de collections. À l'autre extrême, se trouve le raisonnement des pays d'origine qui soutient que ce sont précisément les collectionneurs qui sont les catalyseurs de la destruction de leur patrimoine national. Dans le texte de la Convention, il était expressément mentionné en ce qui concerne les collections privées, que les biens culturels qui forment une collection, un ensemble ou une série, et dont ont été dépossédés la même personne ou par l'exposition desquels a été violée une protection et qui sont entre les mains du même possesseur, sont considérés comme étant un seul bien. La discussion gravite donc autour du fait de considérer la collection comme bien culturel. Le sujet a été évoqué à plusieurs reprises lors de la conférence diplomatique avec la participation toujours intéressante du collègue grec Icprcp, qui a souligné qu'il y avait une tendance à vendre séparément sur le marché international de l'art des collections plutôt que de vendre les collections dans son ensemble. En réalité, les collections n'apparaissent pas comme une catégorie spécifique dans la liste de la Convention d'Unidroit. Cela n'empêche toutefois pas les collectionneurs privés de s'adresser à des organismes internationaux si une partie ou la totalité de leur collection est volée. C'est une raison de plus pour se concentrer sur son développement. C'est sans doute le droit français qui fournit une meilleure approximation dans la détermination de cette notion. Le droit français prévoit que la conversion des différents éléments d'un site confère une cohérence à l'unité et acquiert dans l'ensemble une valeur supérieure à celle des différents éléments séparés. Ces deux éléments déterminent l'existence d'une collection. De plus, la valeur et la cohérence doivent être appréciées en fonction de leur intérêt dans l'histoire de l'art, des civilisations, des sciences et des techniques. Les musées publics répondent aux réglementations nationales qui coïncident essentiellement avec cette collection privée. Les musées privés sont considérés dans cette analyse comme des collections privées. Il faut ajouter à cela qu'au cours des dernières décennies, il y a eu une transition claire parmi les musées privés qui sont devenus des musées publics. Ce mouvement a pour effet principal de transformer un système de propriété qui passe de propriété privée à domaine public. La législation des musées publics concerne essentiellement l'administration et les relations de travail. Les réglementations sur les acquisitions, les decommissioning et d'autres questions importantes sont généralement ignorées. L'interférence des différentes forces sociales dans l'administration du musée est un sujet de grande controverse car elle est liée au fondement de la liberté dans différentes perspectives. L'analyse qui relie l'État aux collections culturelles privées est l'une des questions les plus complexes. Le débat sur la liberté a émergé dans les secondes moitiés du XXe siècle, comme vous le savez tous. Ce sujet revêt une importance particulière pour les musées publics et a déterminé son lien avec les collectionneurs privés. C'est précisément à cette époque que le lien entre les musées publics et les collections culturelles privées s'est intensifié. Ce lien a été plongé dans les débats sur la liberté et la souveraineté de l'État qui visaient à déterminer les cours des expositions et par conséquent l'orientation de l'éducation. Les conditions que les collectionneurs cherchent à imposer aux musées publics, telles que la durée des prêts gratuits, la maintenance des œuvres contenant des collections, les frais de transport, l'assurance, entre autres, sont très fortes. Mais c'est surtout l'influence qu'ont ces collections concernant l'imposition des canons esthétiques des œuvres d'art qui est la plus importante. Cela montre à quel point la dépendance des musées à l'égard des collectionneurs privés et de leur contribution est plus qu'apparente. Dans ces liens très complexes entre collectionneurs privés et musées, ces derniers ont montré une grande vulnérabilité lorsqu'ils dépendent fortement des contributions ou présentent des collections importantes. Les liens entre les collections privées et les musées publics sont régis par les droits privés, comme dans le cas du droit allemand. Ces liens, cependant, ont une polyvalence énorme. Il suffit de mentionner quelques précédents emblématiques sur la scène internationale qui ont transcendé les frontières nationales, comme c'est le cas de la collection Thyssen-Bornemisza à Madrid, et de façon tout aussi intéressante, le musée Weiler à Bâle, créé par l'artiste suisse Ernst Weiler. L'accès public aux collections privées est l'une des questions les plus controversées de notre époque. L'accès au public des collections privées est inscrit à l'ordre du jour culturel actuel. Les musées publics offrent un espace important pour les collections privées. La perception sociale est importante. Ils garantissent l'accès du public aux collections privées et ce qui serait impossible d'une autre manière. Cela aide à surmonter l'incohérence des lois qui déterminent qu'une partie du patrimoine culturel qui est entre les mains privées fait partie du patrimoine national à la seule exception près qu'ils ne peuvent pas être exportés. Le prédicat muséistiquement correct est un autre ingrédient à prendre en compte dans les liens entre les musées publics et les collections privées désormais insérées dans les domaines du droit privé. Pour finir, un système culturel est une construction sociale dans laquelle différents protagonistes convergent dans un paradigme qui consiste en une série de principes et d'attitudes qui déterminent la manière dont les protagonistes pensent, réfléchissent et agissent. Deux paradigmes différents se distinguent parfaitement dans ces contextes où l'intervention de l'État se révèle décisive. L'un d'eux trouve ses racines dans la responsabilité individuelle et collective. Dans ces paradigmes, la structure sociale est horizontale et les pouvoirs se dispersent entre ces différents postulants. Dans l'autre paradigme, le pouvoir est irrémédiablement hiérarchisé et concentré dans les gouvernements. Le deux dépend entièrement des fonds publics. Ces paradigmes, cependant, existent à peine dans un état immaculé. Ils se caractérisent de façon importante par le fait qu'ils sont publics avec des variantes privées ou privées avec des variantes publiques. Les collections culturelles privées, qui comprennent les collections scientifiques et les collections d'art, partagent la même nature. Cet exposé, riche en questionnements, mais maigre en réponses, tient à démontrer que les tâches du droit dans les structures de la Convention sont loin d'être épuisées. L'une des tâches du UNIDROIT, limitée au domaine de la Convention de 1995, serait de reprendre les urtextes et de développer l'action de justice afin que les collectionneurs puissent recourir aux tribunaux internationaux pour récupérer les biens culturels qui leur ont été volés, même dans leur ensemble. Je voudrais finalement attirer l'attention de l'auditoire pour que UNIDROIT s'épanche sur un thème très important dans les marchés internationaux, les documents de provenance, les documents qui prouveraient la possession ou la propriété du collectionneur. C'est un thème qui répond à sa nature au droit privé. Je vous remercie à vous tous de votre attention.
Merci beaucoup, M. Sanchez Cordero, pour cet exposé qui est un excellent pont entre notre session d'aujourd'hui et celle de demain, puisque vous venez de nous lancer un défi, celui des collections privées. Vous savez qu'UNIDROIT, depuis quelques années, a organisé des conférences en collaboration notamment avec Ishal sur les collections privées ici, même à Rome, dans le cadre de notre projet académique. Les universités de Gdansk et Opole ont organisé une autre conférence. C'est un sujet vaste et important, et la notion d'intégrité de la collection est très importante. Je crois que je vais m'arrêter là parce que je ne voudrais pas, il y a des questions qui vont être posées. Alors, une question en français. Je pense que la convention de l'Unesco de 70 et celle d'UNIDROIT concourent à une finalité qui est la lutte contre le trafic et l'appropriation illicite de biens culturels. Je me demande si ces deux institutions ne doivent pas travailler ensemble à travers ces deux conventions pour mettre en place un instrument juridique international qui tient compte de toutes les réalités du moment. Alors, je peux commencer par donner, c'est une question qui est déjà venue ce matin. D'abord, les deux organisations travaillent ensemble depuis très longtemps, depuis la Convention de 1954, UNIDROIT était déjà, collaborait déjà. Nous travaillons ensemble. Alors, la question d'un nouvel instrument juridique international qui tient compte, vous savez le temps qu'il faut pour faire une convention, ce qui n'est pas un motif pour ne pas en faire une autre, le temps qu'il faut aux États pour s'approprier de la convention et la mettre en œuvre, c'est autant de temps, chaque fois que l'on discute de ces questions, les réponses juridiques qui de plus en plus, et celle d'UNIDROIT, tout le monde reconnaît de dire que c'est une convention ambitieuse qui tient compte des aspects éthiques, et on a du mal. Commençons par appliquer ce qui existe, mais à les appliquer. Il ne suffit pas de ratifier les conventions, on l'a déjà dit, il faut les mettre en œuvre. Et sans cela, ce n'est pas la peine de passer à une autre, on va recommencer le même processus pour les mêmes résultats. Donc, oui, UNIDROIT et l'UNESCO travaillent ensemble, oui, à une meilleure mise en œuvre des instruments existants, tout évidemment en créant, comme nous l'avons fait pour les dispositions modèles ou d'autres questions, trouver des textes, des directives qui permettent de tenir compte des pratiques actuelles. Mais un vol est un vol, une exportation illicite est une exportation illicite, quel que soit le contexte. Voilà, donc je crois que sur ce point-là, alors est-ce qu'il y avait une autre
Marina, sorry, Marina, Sophie speaking here.
Sophie, yes, of course.
Yes.
Thank you.
I just want to come back to the question of a new convention, and I just want to emphasize what you said. It's not so much about creating new instruments, but implementing instruments that exist. And that is also true for European instruments. And although there's a little bit more, there's more flexibility for the European Union to change and adapt and modernize its instruments, which has happened with the directive and has happened with the regulation as well. The most important for those instruments to be effective at the European level is European cooperation, is custom training, police training, and this is what really matters now. It's not adding new rules, it's about implementing existing rules in the best way that they can be, and that only can happen with training and development of training and involvement of the different stakeholders, in particular professionals of the art trade.
Definitely. Thank you very much, Sophie. There's a question maybe for Mrs. Martins. A person is from Mauritius, is thanking you for your presentation on the model law. Can you clarify whether the model law brings together in one document principles enshrined in both the 1970 UNESCO Convention and the 1995 UNIDROIT Convention?
Thank you for the question. Yes, in fact, it does. During the development of the model law, we sent the first draft to UNESCO, and we requested UNESCO inputs before they participated in the workshop. UNESCO also submitted the same document to UNIDROIT, and inputs from UNIDROIT were made into the model law. Thank you.
Thank you very much. We have two questions from the floor here in Rome. The first question will be put by Alessandro Checchi.
Thank you again for the interesting presentations of this afternoon. I have one question, kind of two questions, one specifically for Angela Martins of the African Union, and a second question for the other speakers, also for you, Marina, because we are here talking about enforcement. So on the one hand, I would like to know if the African Union in this model law is treating criminal sanctions in a different way. So are there criminal sanctions in this draft, or again, everything is left to member states as we see in the text of the UNIDROIT Convention? And then we said enforcement is key. You should work more on the enforcement of what we have rather than producing new rules. I'm wondering whether we should insist on, with states, to have more efforts on the criminal code. So, okay, we have a lot of development concerning, specific national legislation for restitution, for the protection of archaeological sites, etc. Perhaps the deterrent effect is still missing, no? So perhaps should we insist more on this side? So making sure the states coming forward, asking UNIDROIT and Unesco how to ratify and then implement these treaties, how should inform them also on modifying also criminal laws, criminal codes, to have change, a systematic change, rather than only, again, it's not little, it's not, but not just protection of sites, protection of museums, laws on restitution, but also, strengthening the criminal side of national laws. Thank you.
Thank you for the question. Article 41 and Articles 42 of the AU Model Law on the Protection of Cultural Property and Heritage. One is about offenses, and the other one is about civil wrongs. And what we are trying to do here is sort of advise member states to criminalize this kind of actions. But like I said in the beginning, the model law is a guide for member states to develop their own national legislation. So it's up to the member states to, whilst they are enhancing or strengthening their laws, or they are developing new laws, to use the articles as guides. Thank you.
As the question was also turned to UNIDROIT, if I understood well, but I would also invite all the persons here. Well, this is an example of complementarities between organizations. We all each have our mandate. We do not work in criminal law. Of course, the convention speaks about theft, illegal export, and in some instances, they will need to be decided whether there is a theft or an illegal export, but not the UNIDROIT Convention isn't more in a civil case than a criminal case. But we always said that, and with UNODC in 2013, when they have their guidelines on criminal law, this was the first time when criminal law was focused more. The UNESCO Convention, the 1970 conventions, asks states to develop a criminal legislation having criminal provisions. This is not the case with the UNIDROIT Convention, but for sure, in many states, an offense against a cultural object is considered as less important as against other things. And for this, for sure, UNIDROIT will ask states to realize that it is a specific offense which needs specific sanctions, as cultural property at large deserved and already and today has a specific branch of law. If someone wants to complement. No? So Professor Reynolds, you wanted to ask.
Again, my question is to you, Mrs. Martins. Your presentation was extremely interesting on the model law, and I would just like to know if there are in this text any guidelines or guideline provisions relating to restitution within African states, or perhaps also if there are any provisions relating to restitution claims abroad, or is it not within the ambit of the model law? Thank you very much.
Thank you again for the question. I think the model law looks at restitution as a whole. No matter is related to illicit trafficking within the continent or outside. The other part of your question, I didn't get it properly.
It's whether there's any provision relating to restitution abroad. So claims from an African state towards, let's say, European country. Is there any rule or provision that might affect such a claim?
Yes, the restitution claim provision is about both objects looted within the continent and those which are abroad. But apart from the provision in the model law, there's also the research document that I mentioned before, which looks into specific cases of objects which were looted from Africa or which disappeared on the continent. So we try to provide guidelines to member states on how to go about the return or the restitution of these objects. Thank you.
Thank you very much. Il y a un représentant du ministère de la Culture de Norvège qui nous a demandé à prendre la parole. Il s'agit, it is Mrs. Suniva Sedwick, Senior Advisor from the Department for Cultural Heritage at the Ministry of Culture of Norway. Suniva, you can have the floor.
Good afternoon to all of you from Oslo, and happy 25th anniversary to everybody. I want to thank UNIDROIT for your important work and for organizing this special event under such difficult circumstances. And I'm not talking about technical circumstances. Thank you for your kind invitation to speak at this occasion. I'm very honored. This has been a most rewarding day with many interesting presentations from experts in international law. Thanks to all of you. In the context of this conference, speaking from an operational perspective more than a legal one, I'd like to highlight the vital role of both the UNESCO 1970 and the UNIDROIT 95 conventions in the shaping of national laws and regulations. But not only that, the conventions have also inspired norms and practices that sometimes go beyond their legal implications. They have been instrumental in enhancing global awareness and understanding of the value of preserving cultural heritage. Coming of age, the combination of the UNIDROIT and the UNESCO conventions still constitutes an excellent framework for continuous efforts at national as well as at the international level. In particular, I would like to mention the developing of important practical tools, especially the UNESCO Net Law database, which have been very useful for our implementation of both conventions. But also other important tools, such as the operational guidelines, online training courses for law enforcement, model provisions, etc. For the states that have not already done so, I'd like to emphasize the possible crucial importance of joining both conventions. Ratification of the 95 Convention could in fact play a pivotal role in the outcome of a future return claim involving your country. The relevant provisions of the Norwegian Cultural Heritage Act may serve as an example to this effect. As a rule, we practice a total ban against the importation of cultural objects that have been unlawfully exported from another country. Whenever customs or the police come across an object with dubious provenance, we notify, in accordance with the conventions, the authorities of the exporting country or the country of origin. If they confirm that importation took place in breach of the national regulations, it is standard procedure to report the illicit importation to the police. Then, in due course, we will return the artifact to the requesting state. Now, this is a fairly simple and easy procedure for implementing the provisions of our legislation. Depending on the status of the state in question, this practice sometimes goes beyond our formal obligations. With their transposition into national law, UNIDROIT 95 Convention in 2002 and UNESCO 1907 in 2007, the scope of the relevant provisions was extended to include obligations also towards states outside the European Economic Area. It should be noted that the legal obligations set out in these provisions are strictly limited to states which are party to the same conventions as Norway. This means that if a litigation or conflict of interest should occur, we would need to refer to the list of state parties. Consequently, the requesting state will have a much stronger legal platform for a restitution claim if it has already ratified the UNIDROIT 95 Convention. As long as the involved parties have agreed to restitution, it has not been necessary to distinguish between members and non-members of the Convention. A pertinent question to be asked, however, is whether such an approach to implementing the Convention is enhancing our common cause of curbing illicit trade. Or might it perhaps be an impediment for recruiting new state parties? In my view, the first alternative prevails. Over the last 5 years, Norway has completed several restitutions to countries of origin, the latest being the return to Mali of an old Timbuktu manuscript that had been illegally removed by a Norwegian missionary. Another example is the return of a Buddha statue to Myanmar in 2016. I am pleased to note that in the aftermath of this restitution, Myanmar has chosen to join the UNIDROIT 95 Convention. I do not know whether Mali intends to follow suit. I hope so. The UNIDROIT 95 Convention offers not only a legal framework, it also gives valuable operational guidance for national stakeholders, even in cases where a solution seems out of reach. Here I am speaking from experience relating to the non-retroactivity of the legislation. To conclude, I will once again strongly encourage all states that have not yet done so to sign and ratify the 95 Convention. They should know that doing so may constitute a game changer for their future restitution claims. I'm hopeful that in the coming years, restitution will become the new normal. For ethical reasons, stolen and illicitly exported cultural property should be returned. unless, of course, the involved parties agree on other constructive solutions. Before closing this statement, I'd like to share a small piece of information regarding the Nicosia Convention. I'm pleased to tell you that the Norwegian Parliament next month will be discussing a white paper that includes the proposal to ratify the Convention on Cultural Heritage Crimes. If the Parliament gives its go-ahead, I think they will, ratification procedures can probably start next year. Thank you for your attention, and I'm again very sorry for the technical trouble I caused and the delay. Thank you.
Thank you very much. This was the best conclusion for today. So I again thank all of you, wherever you are, for following us today, and looking forward to the follow-up of this conference. And we'll meet again tomorrow morning at 9:30 Rome time. Thank you so much and good evening.